Please be seated. The High Court Chamber on International Crimes and Cross-Border Crimes resumed the case with RP 0031/2019 HC prosecution versus Sankara and co-accused. All co-accused are present. The accused are represented by the usual defense. The prosecution is represented by the national prosecutors, as usual. And those seeking compensation are here, except 2 of them, but they were notified, so we can proceed. As you remember from last time, the court had given time frame to RUSESABAGINA and his defense, so they can consult and prepare their objections. The court had given them that time frame. They put their objections in writing. We'll give them time to explain their objections. But as you may remember, before we ended last time, there was a question about the obstacles the RUSESABAGINA and his party had while preparing their arguments. The court had decided to consult with prison authorities about those obstacles. So we went to Mageragere prison Tuesday from 2 p.m. and we had a conversation with all parties, the prison management, RUSESABAGINA himself, and his defense, Maitre Gatera, and his colleague. And before we proceed with the objections, I will request the registrar to read the report from those conversations between us, RUSESABAGINA, his defense, and the prison management. Well, we'll make a statement about that, and then we will deal with those objections proper. So, the registrar, please. This is a report on the visit to the prison about RUSESABAGINA's request. On March 1st, 2021, the court, represented by the President, Muhima Antoine, Eugene Dagijimana, a judge, Mukamurenzi Beatrice, a judge, and the registrar, Nyamutama Epax, went to the prison and they met the Prosecutor General, Deputy Prosecutor General Angelique, with the National Prosecutor Ruberwa Bonaventure. RUSESABAGINA Polo's present with Maître Jean-Félix and Gatera. Other leaders in Mageragere prison were present, including Director Kamugisha, his deputy, Yamuremye Pierre Damien, and the former Deputy Director, Beatrice Wamahoro. What RUSESABAGINA in his defense had raised are as follows. They expressed those obstacles on 26 February 2021 here in the court. And those were the following. Inability to prepare their arguments because he did not have enough facilities, necessary means to do so. The fact that some documents related to his case were confiscated by the prison management, which had a consequence in him preparing his arguments, resulting in delays. The way RUSESABAGINA and his defense expressed the obstacles is as follows. They reiterated what they told the court during the previous hearing, that some of the obstacles were related to his documents being confiscated by the prison management, while others reached him with a significant delay, which had consequences which resulted into delay. He also said his medication did not get to him. And he said these were obstacles to him preparing his arguments and getting ready for his case. So he could not prepare properly. Paul RUSESABAGINA says he does not know the number of documents that have been confiscated. He said that even when they return the documents, he cannot know which ones are missing. RUSESABAGINA Paul and his defense say that given that his case is a big case, it's a huge document, the indictment itself is 269 pages, and other related documents, the annexes, are about 3,000 pages. So he says he needs a computer to read those documents and prepare and have enough time frame to prepare with enough lighting to read it. Because so far he says he did not have enough time to read his case because the lights go off too early in the evening. So he says he needs more freedom to consult with his defense. Here is what the prison management says. They said they did not confiscate any documents, but the instructions from the Rwanda Correctional Services provided that nothing gets into the prison without being examined by the management. And that's how those documents are examined, and they are given to him. They do not confiscate that. They said it was the first time to hear that claim. They said he had never expressed that to them. They heard that in the court for the first time. The prison management said that they admitted that sometimes it takes some time to examine those documents. And about the lights going off early, prison management says they'll turn the lights off for the security of the detainees. That's per prison instruction. But they said they were going to look into his claim so he can be facilitated to work on his case. About the computer, the prison management said that if he requests that officially, the prison management, together with other institutions, will look into how he can get that computer. But in the meantime, they will keep printing his documents from IECMS system and give it to him. But they agree that a computer would solve that issue. And about the medication that he claims were confiscated. Prison management says that RCS management say this: no detainee can keep their medications in their cell, but the medications are kept in the clinic, in the prison clinic, so they are given to him when he needs it. But so far, he has never requested to get those medications. Prison management said Rusesabagina is totally free to consult with his defense. The court visited Rusesabagina's cell to assess whether or not he has the necessary means to get ready for his case. He has a desk and a shelf so he can prepare his defense. That's the report from the visit by the court at the prison. Thank you. Well, I think the registrar just gave you a report from our visit to Mageragere prison, where we tried to talk with different parties, and there are many things they agree on, and the court, after that conversation, the court is going to give its stand as usual. That's what the court does as usual. When there's an issue that is raised, the court expresses its stand. Two things we want to clarify here. About the said confiscation of documents and necessary means for Rusesabagina to get ready for his defense, that we have that position. My colleague is going to read where the court stands on those issues. After the talks between all parties during that visit, the court realized that a few things needed to be corrected, including the fact that Rusesabagina Paul did not have all the necessary means to get ready for his defense. Because given the size of his dossier, he needed more means to get ready for his defense, as he had requested, by being given a computer with all the files in his dossier. And his prison needs to give him more time to analyze his dossier. Another thing that needs to be corrected: some of his documents related to this case and others that were confiscated for some time, and for the smooth running of this case, and because of his the detainees' rights, including the law on the National Correctional Services, and as per international principles, the documents related to the case of Rusesabagina Paul, those he exchanges with his lawyers, should not be confiscated. And about as per other documents related to the case, that are not related to the case, or other things people sent to him through his defense lawyers, it should be inventoried and should go through the management of the prison. That's what the court decided. We're not going to discuss that. The court visited the prison to discuss with Rusesabagina his defense and prison management. The prosecution was present too. So that's what we found out, and we want to be corrected, and that's clear. We're not going to debate that. And this is for the smooth running of this case. We do this on every issue that is raised along the process. Without further delay, as we said last time, we said we gave Rusesabagina more time frame to explain his objection. So this is the time for them to come up here and explain what those objections are. Let's remind everyone that we received Maitre Gatera Gashawana's document, who said he was not going to be present here today. He sent a document to the court saying that he would be in Arusha on another case. In that letter, he said that he left yesterday, but he did not say when he would be back. But there's an annex on that document, and it seems like he'll be back on 24th. Well, I'm just mentioning that. Maybe you will elaborate on it. It's an 8-page document. We got an 8-page document signed by Maitre Rudakemwa that you submitted to the court, so please go ahead and explain that obstacle. Rusesabagina and Maitre Rudakemwa, go ahead.
Thank you, presiding judge. Thank you, other judges. I have an objection that I have reiterated many times. I say that I'm here in a way that is not illegal. I was kidnapped. And as I said, the fact that I'm here, I am somewhat like a hostage. So if I was kidnapped and I'm here as a hostage, let me ask, first of all, to be freed, given back my freedom. And I should like my defense lawyer, Maitre Rudakemwa Jean-Felix, to explain this matter to the court very clearly. You have the floor, Maitre Rudakemwa, says the President. Thank you, Mr. President. Thank you, Your Honors. And I want now to explain in a few words this issue, because we have already submitted a document, a written document. Your Honor, we looked through the system and we found that the prosecution has so far not made any comment to our written objection. So we don't know whether we are given the floor just to explain the issue, or we will explain and then a decision will be taken by the court. And because it was said that we have to submit this objection in writing, and by virtue of the legal principle applicable in this matter, we submit a written objection and we expect a reply or a comment. This is my question, sir. Thank you. Thank you. Thank you very much for that intervention. We shall give them the floor to respond to what the defense lawyer said. But before that, let me state that you were late. We gave you time. We said you will submit the document on Tuesday afternoon. But you were late because it was supposed to be we had given you 4 hours. You had actually you had 4 up to 10 in the morning, but rather there are documents that you submitted after 4 p.m. Thank you, says Mr. Rudakemwa. These were supporting documents. No. I'm saying, say the chair, that jurisprudence that you submitted, you were supposed to submit it by 10 a.m. Well, Mr. President, says the lawyer, as we had agreed with the court on last Friday, it was said that the objection will be submitted by Tuesday, which means that Monday, which was really the first working day, after the court, the case, on Monday, we agreed that we will submit the papers on Tuesday. And as you said, there was an emergency, unpredictable, unexpected circumstances, which meant that we couldn't meet with our client, which means that really Monday was not a very productive day because we were not able to meet our client. We met him on Tuesday, and we were therefore able to submit the papers. We tried not to overshoot the deadline, but as you remember, we had to attend that meeting, as you said, which made it as delay. Yes, of course, there is a president, but a part of your documentation came at 4. Let us see if that meeting on Monday really perturbed your meeting with your client. Mr. Rudakemwa has given that complaint. Prosecutor, can you please answer that complaint? Thank you, Mr. President. As the court has just recalled, the documentation was submitted on Tuesday, and it's true it was late. But in fact, the first submission was followed by more documentation on Wednesday, sorry. So we submitted on Wednesday, but even up yesterday at 4:15 p.m., there were more documents still coming. But as we said, we're ready. It's true that the system is a bit slow, but everything has been fed into the system, and we are ready to answer your objections, but we give you also a written paper. No, says the chair. He says they weren't able to read your papers because there is the legal principle requires that they are given enough time to read. Yes. Well, it's their fault, because the last paper came at 4:15. We were not able to respond it immediately. We worked overnight, really practically the whole night, so that we were able to put it on the system, and they will see it. Very well. Mr. President, with your permission. Thank you, Your Honor. As my colleague had just said, we were delayed by the fact that the papers were submitted late. It is not the prosecutor's fault, because the deadline was 5 p.m. 5 p.m. was the deadline for submission of these papers. and they were late. So that yesterday, or rather the day before yesterday, would have been the day for us to give our reply. But we were not given the papers. In fact, the whole day was spent waiting. And it's on even on Wednesday, even at in the morning, 6 a.m. and then later we kept checking in the system, checking, and it wasn't there. Also, Mr. President, the brief was not complete. There were some other papers that came late, one by one, and we were not able to actually. There is a paper they call an affidavit that they submitted yesterday, and they said. So we found that it had a connection with the rest of the dossier, and but it was submitted late. So this is a problem. We did our best. We have already given our reaction, and we are ready to speak to this issue. And we think the argument that he gave about the contradictory argument, he is right, but we are now in a mixed procedure, written and oral. What is very frequently what has been given orally, in the court, may have more weight than the written documents, because RUSESABAGINA, for example, has already spoken. The issue is raised. We raised it previously. We gave him an answer, and so I think we have not broken any rule, or no rule has been broken. Also, usually in court cases, if it turns out that there is an issue that arose later at a later time, where all this, where they are given time. They're given time before the judgment, before the final ruling, rather, to give their arguments, to submit papers, and to do all these things. So I think, but also I think they should really get their act together, because this is a bit of a disturbance. Thank you very much. So we understand that they were late, but they also say that we had to have that meeting at the prison. Okay. So have you any more to say, RUSESABAGINA and lawyer? You said you weren't given enough time to prepare. So, but I think the principle of oral submissions is to be taken into account. Because you can always say what you want to say orally and submit papers and documents later. Do you agree with this? Mr. President, I agree, but because really what we want is a fair trial. A fair trial means or implies that the defense is given enough room and leeway to express itself and present its argument. But you cannot present your case properly if you are not able to see the reply to the issues that we raise, to see them in advance, be able to prepare ourselves before we come to court, come before the court. You say that we can do an oral presentation, defend ourselves, and later on, write present the issue in writing. No, says the president. We are not tripping anybody. The court will not allow anyone to trick or trip anybody. There are no. So you have to assume that this is a fair above board. We're not fighting anything else except fairness in the court. The truth must come out. So you must assume that things are done with loyalty, correctly, and nobody is trying to trick you or trip you into anything. Thank you. Thank you. Well, you know, when you say, Mr. President, that or the prosecution say that, you know, the papers were done, but they were not put into the system, entered into the system. I don't know what they mean. What do you mean? What is your issue? Says the president. You say, no, I haven't finished. No. Says the chair. On this issue, you said why? What is so difficult about entering documents in the system? I said no, just a moment. So I was saying this should have been done in time, so that before we come to here to the court appearance, we have time to find the documents. So I am saying that when they come here, they ask for time to prepare. They're given time to prepare. They submit their paperwork. Then we look at it, and then we communicate with them. We look at that, and then we also reply, or prepare our reply. I think what they should do, Mr. President, is to be given sufficient time to post their reply and answer into the system. Why are you asking for them to be given time? It's not your problem. No, it's not our problem, says the lawyer. It's true, but it's in our interest. Let us ask the court to give the prosecution enough time to prepare, or rather to put into the system all their answers, replies, and so on, so that the debate is properly done. Well, look, says the president, this is another issue. You don't apply for extension for somebody else. They can do their own requesting. You say this is something else. So we're discussing here. They're saying here that their problem is that you did not submit your papers in time. We are ready so long as we have the papers properly. So, says the lawyer, we want fair trial. Yes, says the president. What do you mean? In which way has this issue impeded fairness? Yes, says the lawyer. Well, you see, we come here before you, Mr. President, but before we come, we should have all the papers and properly prepared. No, he says, you can come and present your arguments orally. It doesn't mean that it doesn't impede fairness. Now, can you explain? In what way does these delays impede fairness? Mr. RUSESABAGINA, you want the floor? Yes, Mr. President. I wanted to speak because the prosecution says they received objections on Wednesday. Is that so? Wednesday. Yes, that's what they said. Yes, so, sir, on Wednesday. Between Wednesday and now, 40 hours have elapsed. 40 hours is sufficient to consult, prepare, and be ready. Why are they saying that it's like we have no right to be given enough time to prepare? No, says the president. They did not say, they are not saying that they prevented you from, consulting it. They said, no. you still have time and opportunity to express yourself orally. This is what he was saying. And in any case, you can always give a further document so that you are not frustrated of your rights. Well, you see, I don't know. I think this deprives us of full rights, because we should have enough time to sit down, prepare, read your reactions, prosecution's reaction, have enough time to prepare, and give them, because you see, it's like we present our documents, they're in the system, everybody knows. But for us, for them, they keep their secret, and, they come to court and say, well, we give the argument orally. No, I don't think so. We give our papers. Everybody has access to them. We also have a right to have a previous access or access in sufficient time to their documentation. I think if we sit here, we are all equal. Mr. Gachemna, I think perhaps there is some assistance that you need to provide to your client so that they understand the legal issue. You are giving, you have given your documentation. You are waiting for the prosecution to reply. If you are not satisfied with what has been done, why don't you represent them orally and then they are answered? Now, your right to have the documentation in time, that is another issue. What we're dealing with here, it is true you may not have got them in time, but say what you want here. You have total freedom to express what you want to say here. So, is there a problem, a legal issue? Thank you, Mr. President. I think there is a legal issue. We are not on equal terms here. You're not equally armed, as it were. The prosecution had time to read and discuss and consult what we submitted. I think they got more than 48 hours. I think 48 hours is sufficient for the prosecution to be able to read what we submitted, consult, decide, and present their answer through the system in time. So I think there are 6 lawyers on the side of the prosecution. I do not see how they can fail to provide their documentation this time so that we are on equal terms. We are equally prepared on both sides. So they should give us their papers, let's say, the answer or reaction in time for us to study properly. But I don't think it's right for them to spring things on us like that at the last minute when we don't have time to prepare ourselves. So I was saying, perhaps, Mr. President, that you should give them enough time to present their papers so that we have enough time to look at them, rather than in this situation where we are not on equal terms. Thank you, Prosecutor. You want something else to say? Go ahead, please. Thank you, Mr. President, Your Honor, judges. Thank you for this opportunity to reply to what RUSESABAGINA and his lawyer have just said. As we explained, and we were about to explain again, they are the ones who submitted the objections. They did. And today, we were supposed to answer as prosecution. We are ready to speak or to plead. And we are grateful that they should apply to USA for us to be given time. We do not need any more time. We are ready. Our documentation has already been put into the system. If now, let me recall that during the trial of the 17th, they presented an objection. And they say that this objection had to be examined, where we did, and we presented our arguments on that day, and we can still do it orally.
Argument.
Thank you. I think this matter of fair trial that was raised, well, both legal points and practice and doctrine show that the principle of fairness is respected. What he called égalité des armes, or being equally prepared for the trial, equally armed, that is an interesting issue, because on this particular issue, they are the ones who have raised the objection. RUSESABAGINA is therefore presenting his objection, and we, the prosecution, are defending ourselves, as it were. So in fact, so that we can prepare properly, so that we are equal before the court, equally prepared and armed, we should be given more time. We should have demanded more time, because we were not given enough time. And but still, we did not object. We prepared ourselves. We are ready. So it is ourselves who should be requesting for to be given more time to prepare ourselves. We are at a disadvantage. Not you, because we had plenty of time to prepare. You submitted it, and therefore I do not see how you think this is different from all the arguments that have been presented. You presented various objections, rather. Objections. We have answered them. We have been proceeding that way. So don't try to change things around. On the first day, you presented arguments, or rather you presented objections, but you try to pass them off as just news, just information. So we say, well, no, if it's just news and information, we don't need to prepare a reply. Now that we actually have something that is news, you are now trying to say that there are, I don't know, objections. No, you can't change the name of things as you go. We should be prepared so that every day we are ready to answer your objections, but the ones who raise the objection should not now change them into something else. Just a moment. What do you mean exactly? What are the laws that they have violated or threatened to violate? Mr. President, we're saying that there are laws and legal principles. For example, equitable or fair trial, the principle. In this case, the prosecution is at a disadvantage because we are the ones who are not given enough time. and yet we replied. The other one, when they talk about fair rights, our Penal Code, Article 126, says that court cases are public. That is the first one. First principle of fairness has to be public. Second, the accused has a right to have a lawyer, a defense lawyer, or defense lawyers, and have plenty of time, all the time he needs to express himself. That has been respected. Now, your objection was received. We responded, and in any case, we are ready to respond in court already. Third principle, there has to be, the principle of contradiction has to be respected. And the defense and the prosecution have to be on equal terms, each one given equal rights. And this has been respected. Now, it is now the prosecution that should be raising an objection. Because for example, if you have presented objections, they have a right to do so. And then for us also, we have responded, and our duty is also to give you contradictory arguments to the objections you have raised. So the principle of objection is respected. Also, oral presentations. The oral presentations, the contradictions already before the court, that has been respected, and we are prepared to do that now. So, therefore, if you're saying that there is no fairness or a fair trial, it is not right. It is not true. You are accusing, as it were, because you raise an objection. If you raise an objection, it's up to you to defend it. And then we bring our arguments, and then the court will weigh your arguments, our points and your points, and then they will decide. So, the contradiction is respected. Equity is respected. There is no time where you are never given a proper space to defend yourself or present your ideas. The other thing, if you have given an argument, and now instead of waiting for the reaction of the other side, you say, oh, give them time, they didn't have time, give them time. That it doesn't sound like a correct way of proceeding. Thank you. Thank you. There is something that we need to specify. These objections were presented earlier, but it was presented in the form of information. What you have now done, there is nothing new. You simply maybe selected some of the issues that you presented in the previous paper. They are exactly the same. So, since you have already responded to the previous request, but which you presented as information, you have the answers anyway, because these are no different questions, and therefore there are no different answers. As Paul RUSESABAGINA and his lawyers said, they said they want to know our points, or rather our reactions or arguments. They have them. What you presented is what you said on a previous occasion. You simply gave it another name. You said it was no longer just information, it is now an objection. That's all. and we have already presented our arguments. There are no new arguments. You just took some of the previous questions, represented them, and as arguments. All right. So the proof and the evidence, rather, that we gave that previous time, they are the same. We simply went through the documents and just selected what corresponds to your questions, which your lines, which are fewer than the previous ones. So there is nothing new. Okay, so your objections that you presented in February, 25th February, we answered. We gave no new answers or information. We just selected what corresponds to your fewer questions. But so I'm saying that this is not new. It was the same question that was answered previously, but that you called information and now you call it objection. Okay, so that's all. So there is nothing new. Now, I don't know whether it's a strategy. Perhaps you think that since you can catch us at fault because we were not presented the reply in good time. Well, please, as we said, it is at 4 p.m., 19 minutes that you put it into the system. That also we should look at it, because in any case you kept giving, one by one, sort of, drip of documents. So if you say that the equal preparation and being equally armed, well, I think you are well armed. You have everything that you need, and so do we, by the way, because even what we presented on the 25th of July, or rather the 25th February, is still valid because your questions are the same, your arguments are the same. Okay, so when Mr. President, when we come to discuss or to presenting these issues, during the trial, well, we bring these as evidence. It's the same, and we show that the questions are the same, and therefore the answers are still the same. So please, I think you cannot say that there is no fairness or that we're not equally prepared or armed. It is not true, unless you just want to delay the trial. Because if you are able to explain, or rather, if during the pleading you bring up issues that you have not warned us about, given us warning, well, we'll do like we did the previous time. We say we have to prepare and give our reaction, a document. But right now, everything in the system from 25th of February, everything in the system, you don't want us to have an argument. To present an argument. This is not what you want. I mean, we are not forcing us to prepare an argument. We prepare documentation that corresponds with what you raised. Thank you very much. So, are you saying that there is nothing new in the arguments? That in fact the previous argument that was presented was the same. It's the same as the new one. Yes, sir. Yes, indeed. On this particular issue, this is the same. Exactly the same. Yeah, I think Is that clear? Is that clear? Because they're saying that what you presented is what you had presented in 25th February, and the answers they gave is exactly the same, so that everything is there. Are you clear now?
Thank you, Your Honor, honorable judges. Well, they say they can use the arguments of 25th February 2021. Your Honor, that doesn't mean anything to us, because were that argument the real argument they wanted to put forward today, they would have included that in a comment to the court way before. Then we could have read that. They could have said, we referred to the 25th February argument. Then we would have read that argument. Oh, what's different from what they said right here? What I'm saying is, we could have read that argument. Well, you'd never seen that argument? Well, they introduced different arguments, Your Honor. Well, we're saying that they put many arguments in the system. So if they had referred to that one of 25th, we would have analyzed its content, Your Honor. And we think what they're doing is not correct, because the objection we've introduced today is different from what they pretend we've called information. This is a new objection. We've never mentioned that before. So we don't understand how they've made an argument on that objection before we even introduced it. They're saying that it's what we used to call information. No, this is a new objection. But what they're saying, they will be using their responses to what you introduced before. Well, what they call information has nothing to do with the current objection that we've introduced. So they could not have responded to the new objection on 25th because we had not introduced that. This is a new objection. So everything else that they've said, well, let me consult with my colleagues.
Merci.
Let's resume. Anything else you want to tell the court? Well, we've seen those who are raising hands. We got you. So what the prosecution said, we want to make a comment on that. They said on 12 February we introduced an objection on the eve of a trial. They said they responded to the objection. They say that they can also do the same and do their pleadings orally. Your Honor, let me tell you that after the 17th, the court gave its stand, which is legal, saying that anybody who introduces an objection, well, we've said that way before, even before the objection, from the very first hearing. So we think that the same instruction goes today. The other party cannot neglect that guideline. They've also said that we have a strategy, the defense has a strategy that we've laid out to trap them because they had not introduced an objection. They say that's what we wanted to do, to trap them. Look, Your Honor, implicitly they are admitting that they made a mistake to not introduce their argument because they themselves said that we had a strategy to trap them based on that. No, it's not strategy. We want the law to be respected. But what laws? Explain that. We want to know. We're talking about the laws and the guidelines you give for the principle, about the principle of contradiction that has to be done in writing. Why do they think it was a trap on our behalf? Well, they know, they admit that they broke the law by not introducing this in written form. They also say they introduced that argument very late, so it's our right to take time to analyze it now that they say it's in the system. But tell us, what do you want from the court? You've introduced your objection. You gave your arguments. You are now accusing the prosecution. Now the prosecution that is accused is saying is ready to plead. It's a principle that whatever is said in a trial is the most important thing. That's the principle of oral debate in criminal procedures. So they also say there's nothing new. You had that already. You had that argument. Maitre Gatera said he saw that already last time. Though he said it was information, not objection, but the prosecution had responded. So what do you want from the court? Tell us what you're asking of the court. Here is what we want, Your Honor. We want fair trial, but tell me exactly what you mean by that. You need fair trial. We need to know that we have time to analyze the objection that has been just introduced, that has just been introduced by the prosecution. We want to know what the prosecution has said, its response. That means fair trial. But if they say they did not change anything from the previous argument, well, they should have told us that they were going to use the same argument from 25th February. Then you would have analyzed that. And we think that they cannot use those arguments for this objection because they could not possibly respond to something they did not know, because we only introduced that objection Wednesday, 3rd March. Thank you.
Okay.
You're saying that you need time frame to analyze the objection, the arguments they've introduced in the system, so we understand their response. And you're saying that, and so say exactly what time you need, the amount of time you need to do that. Go ahead, Mr. RUSESABAGINA. We're not asking too much time, Your Honor. We need time to consult on that argument. We need time to examine their response, their argument, so we have the same understanding as a party, and then we come to trial to plead about this prepared. Like my colleague said, we have to be equally armed, so to speak, on equal footing when it comes to this issue at hand. So we will abide by what you're ruling, Your Honor. And well, you're saying that we will rule on that, but you should say that based on this and this. Well, we don't know how much time you need. We're not the ones that are going to examine those arguments. So, in other words, so if we gave you 1 hour to go back and consult and establish whether it's nothing new, is that okay? 30 minutes, an hour? or more time, 1 month, 2 months? Well, that's what he's asking. That's what he's saying. Thank you, Your Honor. For us to establish the amount of time we need, we would first have to look at the content of that argument. So we have no idea about the content of that argument. We don't know the laws they refer to, so we know to counter-argue. We don't know the gist of that argument. So we need reasonable time, and that will have to match my schedule for next week. And I think if you give us Friday next week, given my schedule, Friday next week would be ready to come to trial and explain our objection, and having analyzed the response by the prosecution. Please take your seats. What about the co-accused? Maître Moïse wants to say something. Others, you'll have time to comment on this as well. Thank you, Your Honor. Thank you, honorable judges. I want to emphasize that there are different parties in this trial. And given that RUSESABAGINA's lawyer was saying that he needed to prepare his objections that he could not make public, and you gave him time, more time, and even today, once again, they're requesting for more time. You know, I think RUSESABAGINA in his defense, I don't know what they're doing. It's like those students who are scared of an examination. And each time there was an examination or a quiz, they would say, well, please postpone it. So they said that every time there was a quiz, an exam. And then the students said, well, we want you to give you more time to go and prepare your examination because there's a backlog. So I'm saying this because they keep saying that, well, they're asking for time for the prosecution. How about that? Let me give my lawyer comment on it. Thank you, Your Honor and honorable judges. We will not take too much time. But what we want to remind the court before they decide, they rule on this debate between RUSESABAGINA's defense and the prosecution, we have more than 21 accused here. The court knows this. We have the party that is seeking compensation. They're represented by about 80 lawyers. We've had 3 hearings with only RUSESABAGINA being given the floor. And even today, they're not discussing the substance of the case. So if we keep having such a trial, when only one accused is given exception among 21 accused, this case could go on until 2024. And that's why, Your Honor, like you said the first time, there needs to be a clear roadmap so people know what to be done and when to do it. And those who do not respect the schedule should be sanctioned. Seriously, Your Honor, I'm not speaking for the court, but we're all parties in this case and we have other responsibilities too, including the court. prosecution and the defense. We have a life, each one of us. So I will not take long, but I wanted to make that comment, remind the court of that, so they can decide, rule on this. Of course, it's everybody's right. Everybody's right within every party to make sure they have a fair trial, not just Rusesabagina. But that fair trial also means timely justice. So I'm asking the court to consider all those aspects. Thank you, Your Honor. Anybody else? We'll give you the floor. The different attorneys will be given the floor according to their seniority. Please remind us as well your names and your clients. Your names and your clients. Thank you, Your Honor. Honorable judges, I'm Maître Mugabo Fidel, representing the party of those seeking compensation, about 84 of them, together with Maître Alice and Maître Louise here. My name is Maître Louise Lismolisa, and together with my colleagues, we have about 86 clients today seeking compensation in this case. Maître Mukashima Marie-Louise, representing about 84 people seeking compensation. So our party would like to comment on this request expressed by Rusesabagina and his defense, who want more time to go back and respond to the objection at hand. Your Honor, this is what I want to say. It's the principle about objections. Your Honor, all of us know that an objection is given in limine elitis, which means before we examine the whole issue, any objections need to be raised and discussed by all parties, and the court rules upon it. Let me remind everyone that on 25th January 2021, on that day, objections were mentioned. The second hearing on 17th February this year, objections were raised again, Your Honor. And then there was something unusual. There was that the accused said they were going to introduce other objections, and not that day, and this is the day, the third time we meet in this case. They've expressed that objection. And what is surprising, unusual, they don't want to plead on it when they are the ones who raised the objection. They said they want the other party to be given more time so they can respond before the defense that introduced the objection can make pleadings on it. Article 84 on civil and social and administrative procedures. Article 84 clarifies the time to raise objections. That article goes like this. The person needs to put in writing or in a pre-trial meeting the objection for a case to proceed as per the laws of the land. They need to clarify in their arguments, Your Honor. Well, please remember that the criminal procedures also says something about obstacles. So this is criminal procedures. So based on that article, Your Honor, given that objections were expressed by the defense in their arguments, there's no reason that that party who expressed objections, they have no reason to ask for more time for the other party to go back and express and put their response in writing. And before I let my colleagues speak, if you allow, Your Honor, I think for the defense to be asking for more time is another strategy to delay this trial. Article 17 of the same law says that about suspending the trial, it means that the one who requests that asks the court, and the court examines their request, and then they rule on it. And Article 17 says that to suspend a trial upon the defendant's request cannot be more than twice for the case of a fair trial and timely justice. And now, if we've suspended 3 times because of objections, Your Honor, what's going to happen when we start discussing the substance of the case? How many suspensions? I'm asking the court to not accept these strategies that delay this case. Objections were expressed in arguments. Let the court examine those and rule on those and decide that we go forward and proceed because we have all elements that we need. Thank you, Your Honor. Go ahead, Maître Alice Modissa. I'm not going to take long. What I want to ask the court is this. The court should preserve the rights of all parties in this case. Balancing, what do you mean exactly? I mean the equality of all parties in this case. Obviously, the people we represent here are kind of hostages, taken hostages in this case. My colleague just mentioned that this is the 3rd time we come here. And Mr. RUSESABAGINA and his defense, they keep finding strategies to evade the case, and they do not clarify what they need from the court. We do not understand. Because last time, the Maître Gashabana from the defense refused to express the objection, but he said it was going to be debated today. Your Honor, they have a clear argument, and today they are here before the court, and instead of explaining their argument, they are trying to suspend the trial again. Your Honor, fair trial is timely trial, which gives timely justice. We represent the victims who suffered the consequences of a crime that was committed on them. And today we don't see the end in sight. We have 21 accused. We represent 84 people, the victims. We don't see when Rusesabagina and his defense will accept for the trial to proceed. We are pleading, please, we ask the court to consider that. It seems like one party is, well, he says it's his right to have all the documents in writing from the prosecution. They said they could not have responded without a written document from the prosecution. That's what you said. You heard that. What you're saying, Your Honor, they said the principle of contradiction. So let me clarify what that is. It means a discussion, debate between the parties. It means the defendant gives what they think, and this should be being raised by the prosecutor. It's not the defendant, because they've expressed their objections already. We know, we understand that this is his right, but his right cannot overrun other people's rights. So please, the court should examine that. Go ahead, Maître Mukashima Marie-Louise. Thank you, Your Honor. Thank you, honorable judges. Starting from what the court said about it's the defense's rights, well, that's what they said. We were reiterating what they said. We agree it's their right to raise objections, Your Honor. But a person's right cannot overrun other people's rights. Here is what the law says, and also based on what the defense said. Because they said the prosecution did not give their arguments, which is an obstacle to the principle of contradiction. If you look at Article 126 in criminal procedures, it's about principles of trial, including the principle of contradiction. That's what my colleague just said. Contradiction does not necessarily require to be in writing, Your Honor. Especially that the defendant gave their written argument and the prosecution just responded, it's in the system. But it does not impede in any form Article 126 when it comes to the principle of contradiction. If it's done orally, if the prosecution introduces arguments in writing later, it does not contradict Article 126, Your Honor. Let me emphasize on what my colleague said. Article 15 in the Constitution talks about equality before the law. It's been said already. 3 times we come here and only one person is given the floor with his defense. Well, everybody had the floor. Nobody was refused the floor during those 3 hearings. They gave their objections. You could have introduced your own objections. Everybody was free to do so. I agree, Your Honor, but this is how we see things. All of us are here before the court, and the court protects everybody's rights, including the victims we represent. So we're asking for those rights to be respected and for there to be a fair trial as per 129th article in the Constitution. Your Honor, that's what we're saying here. Please do your ruling on that for the sake of fair justice and timely justice.
Oui, maître. Maître.
Yeah, please, keep the required distance. My name is Ariet Murikatete. I represent Nizeyimana Mark and Bizimana Kasian. Your Honor, honorable judges, we want to react to what Paul RUSESABAGINA and his legal teams have just said, or rather requested. The people that the accused that I represent would like in the cases to be separated. I represent 21 people, including these two, and therefore, Mr. President, since Mr. RUSESABAGINA and his team say that this is a complicated case and long, but if you look at the indictment of the prosecution, the two people I represent, these people are being accused of nine crimes. Therefore, we too can prepare our case, and we think there is a way of avoiding these delays, because the person I represent here is accused on 7 counts. But we have to get through this trial. We want this trial to continue because it is only fair. If you look into the system, Mr. President, you will find that RUSESABAGINA's lawyer, as he said, the papers from the prosecution entered the system this morning at 9, but it is true that it's late. But as it says clearly that in fact this is a reply to a previous question that was objection that were made, but it was not called out objection, it was called information. It's the same information. So the answer is the same. So, Mr. President, we are all lawyers. Once somebody explains why they were not able to place that information in the system properly or in due time, I think people can be given in 30 minutes to go through to just make sure that these are the prosecution said, these are replies that have already been given. It's not new. So can we propose 30 minutes for RUSESABAGINA to go and look at those papers to make sure that they are the ones the same as those they had previously received when they had given their objection, but not as objection about information. So please, sir, I think that is fair. They should be given 30 minutes to just make sure that they are familiar with this reply from the prosecution. And then we proceed. Another issue, Mr. President, I think normally if somebody is delaying and it is clear that it is a delaying tactic, I think Article 18 should be evoked or should apply, whether it is us representing the accused or whether it is the prosecution. If it is clearly a delaying techniques, that should be decided. Yeah. What does that article say? The president said, Article 18 CCCCA. It says here, delaying tactics on the part of the prosecution or the defense or during the investigator. It says here that any any delaying tactics should be waved aside if it is clear. So that is the delaying techniques. All right, I understand, says the president. Yes, it says here, they explain very clearly what decisions are usually taken when the delaying tactics are actually proven to be just that. Thank you, madam. There is another team. Please go ahead.
Maître Uramije James.
My name is Uramije James. You represent? I represent Iyamuremye Emmanuel and Nshimiyimana Emmanuel and Nihiro Marcel. Mr. President, honorable judges, as regards this presentation of objections, I think the side presented an objection, which means that they are in fact accusing the prosecution. So that if you present your objection, you have already prepared. You're ready. You have nothing else to go and read and prepare. Therefore, I don't see the validity of the argument of saying that now I present an objection and then now another objection because the other side has not done this, that, or the other. No. I don't think this is correct. Second point. The prosecution said that the answers are already, the documents are in the system. It's true. We have seen it. We are familiar with that objection. And the answers that were previously given to those objections, even when they were not called so. I think it's wrong. I think it's wrong to delay the system because they cannot say that they are not familiar with what the prosecution has responded. It is not right. You know, we've been here. We've looked at this argument in the system over the last 3 years, the last 3 days. Now, I think that if the accused, I think the accused has already is already familiar with what the prosecution has responded. Second point, I think what is important in a trial is the oral argument, the oral debate. Third point, the Article 127 of the criminal proceedings. I think paragraph 5 says that the legal team, has, or rather, well, actually, the court, let's say, the court has got to make sure that before the court proceedings go on, there are no objections, pending objections. Oh, I agree with this. And I think now that they have presented the argument, the ones who presented it should now, or rather presented the objection, should now be eager to hear what the other party is saying. They shouldn't be postponing. It is a fact that this is a complex case. There are many accused and many other people concerned. So that, but that's not an argument for them not to be given enough time. Except in this case, I don't see how they need all this time. Now, during the pleading, if they come up with something that is a surprise and they need more time, maybe that can be decided at a time. So please, I think, sir, there shouldn't be more delays. What is your conclusion? Say the president. I'm saying, sir, that it should go on, the trial should go on because everybody is aware of all that. We have already read them. Thank you very much. Maître Jean Rugeyo, representing Umwanyira Herman. Mr. President, I shall not come back to what has been said by my colleagues. It is a fact that Paul RUSESABAGINA and his legal team have said that in order for them to, well, they have raised an objection, but they have a right to reading the reply or the reaction of the prosecution. Let me say, I just have one point to say. I think perhaps the time has come for us to have clarity in this. RUSESABAGINA has raised an objection. He is now saying that he didn't have time to read the prosecution as a prosecution's reply. But the prosecution has said that they don't want more time, because they have not asked for more time, that they are ready for the process to begin, that they are ready to plead and hear the other side. So, Mr. President, I think on the side of the prosecution, if they say that they will not be reading, or rather basing themselves on the document that they posted at 9, but will be using arguments or other papers that were prepared previously, because these are the same questions anyway, or the same issue. So I think, why don't we just ignore this answer from the prosecution and just go on with the previous answers that were given to the court. Thank you. All right, RUSESABAGINA, Mr. Udachimwa, you've heard what the other teams have said, those who want compensation and so on, and who think that maybe they are not being treated fairly. They said also that the prosecution say they will use the dossier, the document that was prepared previously, not the 9 o'clock one, because what you objected to is no longer valid. They will not use the document that you say was too late. They will use the documents of 25 February, which is exactly the same. Now, there are also other things that were said. You know, the other team said that you are delaying, and normally you should be in a hurry to go through the trial, normally. So can you express yourself? We've heard all the parties, and we know we'll be able to decide or to rule. Yeah, so be brief. Mr. President, thank you very much. We'll be brief. What the various interventions that were just made by various accused and their lawyers we think they have a different outlook on this issue. I think, so far as we are concerned, we want to protect the rights of my client. We will not take into no, says the chair. Please, can you be brief? The prosecution says they will use the document that was done on 25th. Do you agree or not? Yes, Mr. President, we've already said. We've already explained. If the prosecution had said, we want to use the 25th February argument, they should have said so earlier. They have said so, but this is not what they put in the system. No, come on, please. There is a chair. No, just a moment. Has anything changed to what you said previously? Well, we don't know. We don't even know whether they are the same. We don't know. We don't know the content. So please, is your accusation dependent on what the prosecution will say? Why? Yes, Mr. President, is a principle of contradictory debate. Well, look, that means that you put your accusation and then the others defend themselves, and then you are given enough time to speak. Okay, so we've had that. If you have no other argument, please, maybe RUSESABAGINA has something else to say, but don't bring on these other issues. No, there is nothing new, sir. RUSESABAGINA, thank you. Very well. So give us time. There is 10-15 minute recess for the court to deliberate and rule on this issue. Thank you.
judiciary.
Please be seated. We resume the proceedings. Please bear with me. My voice is not as good as it should be today. The court wants to communicate to you its decision about Rusesabagina's request. My colleague will read the decision, the ruling. After hearing Rusesabagina's request, saying that they cannot explain their objection, having heard Rusesabagina Paul's request, together with his lawyer, Maître Rudakemwa Felix, who say they cannot explain the objection they have introduced about his provisional release, saying that because the prosecution did not respond on time to the objection, having heard that the prosecution is ready to do the pleadings because Rusesabagina is the one who introduced the objection and should explain it, having heard that there's nothing new that the prosecution has introduced in their arguments today, because, as they say, the content of their response is what they had introduced on 25th last month, because even though it was a response to what the defense was calling information that they call objection today, having heard the other parties saying that Rusesabagina's rights cannot overrule those of other parties, having heard that Rusesabagina say he's not ready to do the pleadings on the objection, even though he's requesting for a provisional release, knowing that he can introduce objections at every step of the trial, and based on the law on criminal procedures, especially Article 96 and 97, the court decides that the trial is going to proceed. And when Paul Rusesabagina will be ready to introduce his objection, he will do so. He will be given the time frame to explain his objection. That's the court's ruling. So we're going to continue the proceedings. As per the law, Rusesabagina is the one who introduced the objection, asking the court to release him on a provisional basis. That decision has no incidence on the rest of the co-accused. So whenever he's ready to explain his objection, for the court to remove the decision to keep him in prison, he will do so. So we will continue with the trial. Part of this case involved Sankara, who had explained his arguments. The case was in substance already. The prosecution explained, made its case, and Sankara responded. So we're going to continue with Sankara. But before the judge gives you a recap and what it takes for Sankara to proceed, Maître Rudakemwa wants to speak, so he'll go ahead.
Oui, Maître Odakem.
Go ahead, Maitre Rudakemwa, please.
Murakoze Nyakubahwa Perezida.
Thank you, Your Honor. Thank you, honorable judges. Having heard the court's ruling on what seems to be an objection that we had introduced, we want to tell the court that Mr. RUSESABAGINA is ready to explain his objection so the court can analyze it. Thank you. I don't understand that. Please explain. Thank you, Your Honor. After having heard the court's decision on the debate in today's proceedings, now that the decision is that RUSESABAGINA has the right to clarify his objection at any step of the trial, and that the court was saying that they were going to continue with Mr. Nsabimana Calixte, we find that, as the court had said, right now Mr. RUSESABAGINA is ready to explain his objection. You mean another objection? You mean the objection you just ruled on? No, the objection he introduced in a written form, the one that requests for him to be released. How about the court's ruling that we just read? Well, that ruling said at any step of the case, whenever Mr. RUSESABAGINA will be ready to give his objection, he will do so. You mean that the court's ruling has just played in your hands? Now you mean you're ready to go ahead? That's right, Your Honor, we're ready. So let's hear the other party. Does the prosecution wants to comment? Go ahead, the prosecution. Thank you, Your Honor. On the side of the prosecution, we don't see any obstacle. If his conscience tells him that what he called objections today are no longer an obstacle, we are ready to do the pleadings, to make the pleadings. We have no objection against that. What's obvious is that they were only trying to delay the proceedings. But for us, we think the trial can go ahead if he thinks he can explain his objection, and so we can make pleadings on it. They have just delayed the proceedings. Thank you. What about other parties? Do you have any different comments to make? If anybody wants to speak, go ahead. If there's none, then we can rule on it. So there's nobody else. Please allow us to consult. We're going to suspend the proceedings for a short while so we can consult in a different room. Please be seated. We're going to resume the proceedings. Those who don't know the court's procedures, this is normal in court business because we need to coordinate our understanding as judges here. So we had just said that we're going to resume the proceedings. So whenever RUSESABAGINA and his defense are ready to explain the objection, they'll do so. So now they say they're ready. That's good. They can go ahead and explain the objections. Then we would resume on a later date for the rest of the accused. That's the court's ruling. Thank you, Your Honor. As I had introduced earlier on today, I want to give the floor to my lawyer so he can explain at length the objection I was talking about. Thank you. Go ahead, Maitre Rudakemwa. Thank you, Your Honor. Thank you, honorable judges. Thank you for giving us the floor so we can explain the objection we introduced in writing. Now we're going to explain it orally and at length. Your Honor, as you know, last time we were here on 26th February this year, this court had ruled on the objection of jurisdiction as it was introduced by Paul RUSESABAGINA and his lawyer. So the last time's ruling was that this court had jurisdiction to try Paul RUSESABAGINA. Today's objection is very different from the other one from last time. Paul RUSESABAGINA is asking the court that this, before it can try his case, it should remove the decision to imprison him. They should remove the provisional detention decision. If that decision is removed, Your Honor, as we will explain, all the proceedings of this trial will stop because, as we will explain, they would stop because RUSESABAGINA was brought to Rwanda illegally, and as a result, since he was brought to Rwanda illegally, if the court removes that decision to jail him, he would be a free man as he was before. As he was before he was abducted and brought to Rwanda. Your Honor, this objection is based on the law, especially Article 96 of Criminal Procedures Code that provides that in paragraph 3, it says, a person accused of a crime who was put in jail provisionally can request the court that decided to jail him to remove that decision. What we call removing provisional detention decision. It says that the court analyzes that request before it can try that case. That's the objection we wanted to explain, Your Honor. And then we want to prove that Mr. RUSESABAGINA was abducted and brought to Rwanda illegally, which will lead to you removing other decisions that followed that abduction. So you will remove all those decisions, and my client should not be here because he is here based on acts that was illegal. Those acts need to be removed. Your Honor, as we've explained in our argument, Paul RUSESABAGINA was arrested in the night of 27th August 2020. 27th, in the night of 27th August. Paul RUSESABAGINA was abducted and brought to Rwanda illegally. He was put in jail, he was arrested, put in jail, and everything was illegal. All that process was illegal we're saying that because this was not based on any law. Your Honor, normally when a country wants to try a suspect who resides in another country, it has a due process. That country that want the suspect to be brought, they request the country of his residence. Then the courts of that country of residence, the appropriate courts, they rule on that request. They rule on the extradition, and it's a court decision. And on this matter, we're saying that Paul Rusesabagina did not benefit from that process. That's why we're saying that him being brought to Rwanda, there's no other words to use. It's simple, plain and simple kidnapping. And this, Paul Rusesabagina has tried to explain that when he was before the Investigation Bureau. He said he was brought to Rwanda illegally. The investigator explained it at RIB. RIB transferred him to the parquet. He explained the same thing. He explained how he was arrested illegally, and nobody wanted to listen. And then he was taken to Kicukiro court to establish whether his arrest was legal. Even then, Mr. Rusesabagina tried to tell the court that he was brought before that court illegally because he had been brought there illegally, as we've just explained. But the court did not want to listen to him. They decided to keep him in jail on a provisional basis. Back then, that court in Kicukiro, Paul Rusesabagina has expressed his wish to choose his own legal team, but his right had not been granted. He was being represented by an appointed attorney, appointed in mysterious ways, according to Rusesabagina. And he was he had two lawyers who had been appointed, and he didn't know why they had been appointed when he had the capacity to appoint his own lawyers. He had been denied that right. He explained it to the court because he had the means to pay his own lawyers. He didn't understand why those two had been appointed. And the court back then did not want to listen. And the court decided for him to remain in jail on a provisional basis. He appealed that decision. And like I said, that's why he wanted to come before this court for this trial, for this case to be tried in depth, so the court can remove that decision to detain him on a provisional basis and remove all other proceedings that ensued. Then the consequence would be that he would be released without any condition. Then he would recover his freedom. We've also explained to the court that Rusesabagina was arrested in Dubai, in the United Arab Emirates. He was brought to Rwanda illegally, with no due process. We proved that his being brought to Rwanda, he didn't have any entry visa to Rwanda. We've also explained that since 2004, when he was in Rwanda last, he came to Rwanda on a visa. And this is the thing. How is it possible for a person who's the prosecution admits he's a Belgian citizen who could not be tried by Rwandan courts, was arrested, abducted, and brought to Rwanda? We've clarified, we've mentioned the prosecution's own admission in its indictment that they could not have tried Mr. Rusesabagina, who is a Belgian citizen. He could not be extradited to Rwanda to be tried here, and that's why Rwanda's prosecution requested the Belgian counterpart to try Mr. Rusesabagina in Belgian courts. It's not understandable how they contradicted themselves and brought him here through kidnapping, as we've established in our written document. The Belgian courts had started trying his case already. We don't know why that process in Belgium was overlooked and my client was abducted. Your Honor, we've also explained that even as per our internal regulations, there's a normal process to ensure that a suspect is brought before justice. That's Article 129 to 131 in our Criminal Procedures Code. Rusesabagina had a known address. He had a known address. Why didn't no normal procedure was used to bring him here? Extradition was not used because it would have been possible if they had reason to believe he was suspected of a crime. What other normal process are you referring to if not extradition? Please explain that. The normal procedure is extradition. If Rwanda wanted him, they would have requested Belgium or the United Arab Emirates legally, and then they would have examined the request. If the conditions were met, then they would have ruled on extradition. But that never happened. And for us, that means that he's here before you illegally. That's why we request that he be released unconditionally. And that abduction, Your Honor, as we've explained, was confirmed by the prosecution's witness. The prosecution brought its own witness, named Bishop Constantine Niomongere. This witness confirmed the fact that Rusesabagina was abducted, Please move closer to the microphone. He said this in writing on 27th February 2020. He repeated this in a written report before the Investigation Bureau on 28 August 2020. And again, on another report, in an additional report on 16th October 2020. This Bishop Constantine Nyomwongere clearly explains that he collaborated with the Investigation Bureau, RIB, in planning and executing the plan of bringing Paul Rusesabagina to Rwanda. He explains, he talks about a plane that abducted him from Dubai to Rwanda, that it was chartered by RIB. He also explains how everything happened. When I'm talking RIB, I mean it's the government. The government did this. And this means that that kidnapping really happened. And those reports, this Bishop Constantine Nyomwongere, he says the same thing as Rusesabagina. Rusesabagina says he left Dubai thinking he was headed to Bujumbura. That's what Nyomwongere says. He says this: we tricked Rusesabagina into believing he was leaving Dubai for Bujumbura, but the reality was that they were bringing him to Kigali. This Nyomwongere says that once they were aboard the plane, the pilots tried to say that they said the plane was headed to Kigali. Then Bishop was concerned, and he told the pilots that they should not say the destination again to avoid Rusesabagina knowing what was happening. Then the bishop says the tricks he used to divert Rusesabagina's attention. That's his own words. Those are his own words. And this confirms that Paul Rusesabagina was kidnapped from Dubai. He thought he was headed to Bujumbura, but because of the tricks that were used by this bishop together with the Investigation Bureau, Rusesabagina was surprised to find himself in Kigali without any document, which proves that this kidnapping, until this moment, he's here illegally. So we request the court to respect the law, especially Article 9 of the International Convention on Social and Political Rights. It's about the correct process to arrest a person, the person's rights, that nobody can be denied his right and be arrested illegally. There's an article about that, and the court should read that article as we have requested before. Anybody arrested illegally has the right to reparation. And that reparation, Your Honor, since we've established that the whole process of arrest and imprisonment and extradition was never respected, reparation is no less than releasing RUSESABAGINA without any condition and removing any other decision against him until today, because those decisions were taken on based on an illegal process. Of course, we've referred to laws, including Article 43 of Criminal Procedures Code, especially Section 9 about illegal arrest, illegal imprisonment in paragraph 1, including being imprisoned without any proper arrest process. So since those were not respected, all other decisions based on it were illegal, and Mr. RUSESABAGINA needs to recover his rights, because what do you mean was not respected? What steps were not respected? It's what I've just explained, that if Rwanda wanted him for trial, they should have gone through extradition process. That's what you mean, extradition? That was not respected? I've explained. So what I'm asking is this: what are those steps that were not respected? Extradition? Extradition and the acts that were taken and decisions taken after he was brought here, because they were based on an illegal process. We've shown jurisprudence in other countries, especially in Commonwealth countries, and we share same legal culture with Rwanda. We've tried to show jurisprudence in the UK, in New Zealand, in South Africa, and in Australia. We've tried to show that those countries are all Commonwealth members, and all of them show that all of their courts, those courts declared they did not have jurisdiction to try people who were brought before them illegally. We've referred to those jurisprudences, and we ask you, Your Honor, to consider those for this RUSESABAGINA to be given his right and returned to his normal life, because he was arrested illegally. What do those jurisprudences say? What is the substance? How is it related to RUSESABAGINA's case? Those jurisprudences, Your Honor, we proved that the courts in those countries, the UK, New Zealand, South Africa, Australia, they admitted they did not have jurisdiction over they refused to try people who were brought before them after having kidnapped, abducted. So we find that jurisprudence, as we've said earlier, should be examined and applied to Rusesabagina's case was brought here in the same manner. We've proved that courts in those countries who did not have jurisdiction over such individuals is what you could do in this case.
I don't get you. You are saying that we should rescind all the decisions that were taken in regard to Rusesabagina. Yes, as a lawyer, because he was abducted. Yes, as a court. The jurisprudence that you cite, the precedent that you cite, do they have to do with rescinding all the acts or releasing, or because what is the substance of the precedents that you're citing? Well, those precedents concern all the issues or the aspects that you've just stated, Mr. President. Illegal detention, subsequent decisions and acts, and therefore, based on this jurisprudence, the person or my client should be released. We have submitted in writing all these cases, and I think they substantiate the case of our client. Therefore, in concluding, I will reiterate the various issues that I raised in our affidavits and in the precedent cases that we cited. Some of these issues were raised by you, sir, this morning. What are they about, says the President? You say, I touched upon them. Which did I touch on? No, Mr. President, these are not objections as such. I just want to cite them so that every issue is decided upon and ruled upon, so that there is a fair trial. Just a moment, please.
ngira ngo twabanza tugasuzuma ibi birebana n'inzitizi ibindi birebana n'imitegurire.
I think let us begin with the objections. These are the issues, some of them have been resolved or discussed, but let us proceed with the objections. First of all, since the issues that you raise, you are not raising them as objections. Okay, so we begin with the objections so that the parties can discuss this. Lawyer, have you concluded? Have you concluded your intervention? Yes, yes, sir. We conclude by saying that my client, RUSESABAGINA, was brought here illegally. No law was respected. In fact, he was abducted. And therefore, he should be released unconditionally and be returned to his normal life. That's one. A second, please nullify all other acts that were posed after his arrest, illegal arrest, and declare them null and void. Thank you. Thank you, says the President. Mr. RUSESABAGINA, do you have anything to add? Your lawyer has concluded. Thank you, Mr. President. I want to thank my lawyer who has explained fully the issue at hand. I just want to insist on two aspects. One, the issue of kidnapping, as he just said, and I said at all levels of this process, wherever I went, and it was never discussed, there was never any trial or debate, so that there was no actual ruling. That's one point. Second point, I'm here illegally because, in fact, I should be tried for being here illegally, an illegal immigrant. Whenever I came, 2003, I had a visa. 2004, I had a visa. This is the only time that I'm here as illegally. So that my being kidnapped has led to my being now a hostage. I am a hostage that had been kidnapped, and all my rights my human rights have not been respected. And I think this is an important issue. If I can come back to the issue of competence, you will find all this all in the system. I don't have access to the system myself, but I'm sure, I know that the British police kidnapped one person from South Africa, took him by plane to the UK. Once there, a lawyer said that it was shameful to have kidnapped this person, and therefore the court declared itself incompetent to try an illegally brought person. So the person was released. There was a similar case in South Africa itself. In Namibia also, the lawyer didn't mention all these issues. There are many other Commonwealth countries where people were kidnapped and then eventually they were not able to be tried. But Namibia, a person from Malawi was abducted and he was not able to be tried because it was illegal. Australia, the same. New Zealand, the same. These are some of the examples where Rwanda should also take a leaf from these other jurisdictions and, in their wisdom, review my coming here and my being here illegally. Thank you, Mr. President. Thank you. Thank you. Prosecution, do you have anything to say to what Mr. Dechemga and Mr. RUSESABAGINA said? And if they too have a further comment to make, they are free to do so. Thank you, Mr. President. Honorable lawyer, honorable judges, I take the floor after listening to the explanations by Paul RUSESABAGINA and his defense lawyer, and considering that these issues have also been filed into the system on the 3rd of this month, we wish to make the following statement. What they are asking is that it be ruled that he will be released based on Article 6 of the Penal Code. Therefore, the reasons why he was provisionally imprisoned have not changed, and one wonders why they are bringing up this issue now. Nothing else has changed ever since. Second point, Mr. RUSESABAGINA and his lawyer explained that they want unconditional release. Those are their words, saying that he was kidnapped. Then they also said that extradition was not the issue. Rather that it's not that they didn't apply for or obtain extradition that they are challenging. They are just challenging the issue of his being imprisoned after being kidnapped. We shall give an explanation and evidence as well of what we are going to expose. I should let it be recorded, Mr. Chairman, Mr. President, rather, let it be recorded that the issues just raised have been raised in on a previous occasion, and at that time they had explained to the court that these were objections. Then they said they were just information, and today what they have raised and put in the file or in the system is exactly the same as the previous text that they had submitted. Example. For example, the argument that they made on the 24th February, paragraph 23. So this is the 24th February dossier, and as you can see on paragraph 23, they have what they called a request for remedy. This is already in the system. That this particular aspect was entered on the 21st January, paragraph 26. What we are saying is what we said earlier in the day. They presented their objections, and they said they insisted that this was new. But as a matter of fact, there is nothing new. What they had in the system previously was the same as they brought up again, but we're ready to discuss this or to explain. So I think how we should proceed is in 3 stages. First of all, let us see what kidnapping is about, what laws, what international law and Rwandan law provides about that. Second, and then we will show also the consequences of abduction or kidnapping. But mind that the prosecution does not recognize that he was kidnapped. We do not. But still, we go through these precedents and this jurisdiction, maybe so that the court is ready. Yes, says the president. There was two issues. There was kidnapping, and also the fact that he was tricked. He was tricked. Yes, sir. I will explain that, says the lawyer. We do not believe he was kidnapped, but we shall go along with the exercise so that the case, so that the court is well informed. We have also other jurisprudences and other cases. The case that we have here is not a case of kidnapping. We will explain that, but let us begin by explaining what has been cited as jurisprudence. That's one part of our intervention. Second part, the way RUSESABAGINA came to Rwanda, the prosecution will give evidence of what we are affirming, and in any case, all the lawyers, the judges rather, have all that in their dossier because it's in the system. You remember that we submitted a document requesting a witness to be brought today, because that witness would show clear evidence of what really happened. We have made this request formally. It is in the system, sir. The third issue or third aspect. Just a moment. I don't get your point. What did you say? The witness comes to testify about what? So let us know exactly what you are saying. Thank you, Mr. President. What the prosecution is explaining is that in this second part of explaining how Mr. RUSESABAGINA came to Rwanda, we have a witness that the prosecution have requested the court to admit their evidence when we come to the trial, especially concerning what the lawyer and RUSESABAGINA himself has said. There is a witness called Sadeko whom we wanted to be allowed to bring, because that witness would have shown very clearly how RUSESABAGINA came to Rwanda. The request of this prayer on the part of the prosecution was expressed many times ago. It's in the system. Yeah, thank you very much. I think it's clear now, says the president. Thank you, sir. Now, there is a third stage to our discussion. His detention was legal, and the whole process was in full conformity of the law. But also, if an accused has objection to what has been provided for, they have a right to object, and he has done so throughout the process. So these are the three aspects, Mr. President. And RUSESABAGINA has said, for example, that he was not helped in his defense, in preparation of his defense. The decision that was, or rather, the dossier that submitted on the 3rd did not specify exactly in what way his defense did not satisfy him. What was the problem exactly? But he did ask some of the questions, and we have already responded to them with evidence showing that he was never at any stage deprived of his rights. So these are the three things, the three chapters, let's say, that we want to deal with. And now, with your permission, Mr. President, my colleague will begin explaining these. Maître Jean-Pierre, you have the floor. Thank you, Mr. President. On your honor, thank you, honorable judges. As my colleague has just said, and his lawyer confirmed, he said that he was kidnapped. I am in this first part that we have just, my colleague had just announced. I will now discuss the issue of kidnapping or abduction. Was there kidnapping? What happens when there is kidnapping? I am saying what happens with regard kidnapping, but I'm not saying that that our position is that he was kidnapped. He wasn't. But I will explain the point of law. So I will explain the first chapter as the introduction had just explained, and then another colleague will deal with the second and third. Mr. President, Mr. RUSESABAGINA has not been able to explain how he was kidnapped. He did not say what happened to him, so that to conclude that, Mr. President, this and that happened, and therefore I was kidnapped. No, he didn't. Now let us explain this. Abduction or kidnapping in international law. We are not talking about internal law, but international law. Governing the manner in which a person leaves one country to go to the country where he's supposed to go before the courts. So what we have to make a distinction between internal law and international law, or domestic law and international law. Paulson, in his book Malecautus Benedictentus. Don't go too fast. Don't go too fast because they are recording. Yes, I will slow down a bit. No, it's not the voice. It's not the voice, it's your rhythm. Be slower. Yes, be mindful of the fact that they are recording. So, Mr. President, thank you. Mr. President, Mr. RUSESABAGINA and his lawyer said that he was kidnapped or abducted. Well, the kidnapping we're talking about is not the same as the kidnapping as understood in an internal or domestic law, where a person is, abducted and then taken to another place. Well, there are specific laws for that. Mr. RUSESABAGINA said he was abducted from Dubai, came to Rwanda, but he didn't want to come to Rwanda. So this is not domestic law, is international law that applies. Therefore, we will respond to his position, but it being understood that we do not accept that it was abduction or kidnapping. We're just explaining the point of law. Paulson, in his book Malecautus Benedictentus, this is in Latin. It means, well, it's a Latin principle saying that you can be abducted, but be imprisoned, abducted, therefore illegally, but imprisoned lawfully and legally. So this is explain this on page 39 of this law, or this book.
Obtain custody of the suspect residing in State B without that Leiter's consent does not involve non-violent techniques such as deceit, fraud, trick, but plain force. One could hereby also think of the threat of use of force. For example, if an agent visits the suspect and while holding him at gunpoint, orders him to come with him to the forum state. Mu magambo make aha yashatse kuvuga ko.
So what Paulson is saying is that kidnapping or abduction, there are alternative words. Kidnapping or abduction are means whereby country A have a suspect in a country, in another country, country B, and then they obtain that person as presence through means that are non-violent or without use of force. Whereas you cannot be kidnapped if without force. There was no force. So you can only be kidnapped if the force was employed, forcibly brought from one country to another by use of force. This lawyer is also confirmed, his point is confirmed by L.L. McDermott. McDermott says in his book, Extraterritorial Objection Under the Framework of International Law, in this book, on page 70, this author says or discusses a kidnapping. And he said kidnapping
involves a degree of physical coercion, restraint of freedom of movement, and a threat to the personal integrity of individual. The main right triggered by such a conduct are the right to liberty and security of persons and the right not to be subjected to arbitrary arrest or detention. As the arrest is carried out on a foreign soil, it is necessary to consider the extent to which a state's human rights obligations attach to the extraterritorial operation.
This writer says this: for there to be kidnapping, there has to be a degree of physical coercion or use of force for a person to be taken from point A to point B as a country. And he says, for there to be kidnapping, it's done on a foreign soil in such a way that the sovereignty of that country is violated through that kidnapping operation, because it's done by foreign agents. Your Honor, I was clarifying the context of kidnapping. It implies use of force to take a person from country A to country B using force so they can try that person. Your Honor, for there to be kidnapping, there has to be use of force. For a person to be taken from country A to country B. Moreover, agents of country B agents from country B, for there to be kidnapping, agents from country B play a role in violating country A's sovereignty, because that's where that person resides. It is. Your Honor, honorable judges, based on those definitions about kidnapping or abduction, according to international law, we've established that the way RUSESABAGINA arrived in Rwanda cannot be called kidnapping, because when you analyze his statement, but before you carry on, what are those international laws have you mentioned? You're only referring to scholars? Yes, what scholars have written? They spoke about a context of kidnapping, and it's different from what RUSESABAGINA and his defense say when they say that they should have used extradition. That's what my colleague will clarify. I also mentioned that those scholars defined kidnapping. It uses force, which is different from extradition, because that is a different thing, because it's about conventions between two countries. I've also said that in case of kidnapping, country B intends to try a suspect who could not be brought to country B through extradition. Even apart from kidnapping, there are other ways. I'm not going to go into that. When a person has to be brought from one country to another. And based on what we've mentioned, what happened with RUSESABAGINA is not kidnapping, because based on the definitions we gave, which themselves were given by scholars, also based on his statement on September 11th, when he was before the prosecution on Act number 33, he was asked to explain how he arrived in Rwanda. And as he often says, he says he's a U.S. resident. He left the U.S., but he's now here in Rwanda. The prosecution asked him, and he explained that he left his home on his own will. He left his Texas home in the United States of America, flew to Dubai. That first stage, leaving Texas to Dubai, he was doing his business. He also explained that from Dubai to Kigali, where he was arrested, that nobody coerced him, nobody forced him. It's in his statement. The court will be able to read that document. If you allow me, I can repeat it for the sake of reminding the court. Please say that briefly. Just one excerpt on the question number 33. He says this, that's his RUSESABAGINA speaking. I left the United States of America on 26 August 2020 at 7 a.m. I had a flight to Chicago. I took a flight to Chicago. And then I took another flight to Dubai at 8:45 p.m., arrived in Dubai at 7 p.m. on 27th August 2020. As I was getting out of the aircraft, I was late when I tried to get my luggage. I left the airport at 8:30 p.m. I was very tired, and checked in Ibis Hotel at the airport. I took a shower, getting ready to go to another airport for another flight. I left Ibis Hotel in a car took a 1-hour trip to take another flight to Bujumbura, Burundi. I was with Bishop Constantine Niomongere. He's the one who welcomed me. We went together to my hotel room where I took a shower, got ready to go to another airport. That other aircraft was a private jet that we took. I was thinking I was flying to Bujumbura. I never knew that the aircraft was headed to Rwanda. I only knew when I saw the Rwandan military at Kanombe Airport. I arrived in Kigali on 28th August 2020 at 5 a.m. Because I was very tired, I slept for much of the flight. But before we reached destination, they woke us up. I could see, but I didn't know Bujumbura. I had never been there. That aircraft landed with me thinking I was in Bujumbura, and I was surprised to find myself in Kigali. That statement, Your Honor, proves that is Rusesabagina's statement. It shows his itinerary from Texas in the US to Dubai, and from Dubai to Kigali, even though he says he arrived in Kigali thinking he was going to Bujumbura. But that statement, nowhere will you see him saying that use of force was used. So if you remember that our definition, no use of force or coercion was used on Rusesabagina from the US to Dubai, or from Dubai to Kigali, where he arrived thinking he was in Bujumbura. There was no use of force. He says this himself. What Rusesabagina is, well, is there any other element about violating the sovereignty of another country? Was that involved? No, there was no violation of sovereignty. There's no government, no agent of the Rwandan government who is mentioned in this itinerary. There's no government agent who was mentioned from the US to Dubai or from Dubai to Kigali. The only government agent is seen in this at Kanombe Airport, where Rusesabagina was arrested. We cannot say that any country's sovereignty was violated. No agent from the Rwandan government went to the US or to the UAE for this Rusesabagina to be brought to Rwanda. I will not explain how this happened. My colleague will be talking about exactly how he arrived in Rwanda. I was establishing that there was no kidnapping, and I'm contradicting what Rusesabagina says. There's a question here. We have a question. would you explain, when you talk about kidnapping, you clarified two things: use of force, and for you, what does use of force mean to you? For somebody to be said to have used force? Your Honor, if I had enough time to prepare, more time to prepare, I would have analyzed what jurisprudence says about use of force. But let me say this: for there to be use of force and to be referred to as such, a person has to be taken from where they were and be taken to another destination by force, without him being willing to go there. And so it means that a person would be taken from point A to point B, but without that person playing a role in it to go there. And for RUSESABAGINA, from Texas to Dubai, he did that willingly. He boarded that aircraft willingly. The flight to Kigali, he boarded that aircraft with nobody forcing him to. Nobody grabbed him and threw him on the flight to where he found himself ultimately. Jurisprudence could clarify how use of force is defined, with violence maybe, or force. That's how we can answer that question. So you mean a physical constraint? How about moral constraints? I'm not. Can't that be called force? My colleague will go into that. But in case of moral constraint, you mean trick? That is not kidnapping, and we've clarified that in the definition. Your colleague will clarify, then you can carry on. Thank you. Okay. We've established that there was no use of force for RUSESABAGINA to leave the US and arrive in Dubai, or from Dubai to Kigali, which is what he says is that his kidnapping occurred in the Emirates. The judge asked me, how about violation of another country's sovereignty? I've clarified that no government of Rwanda's agent was in those countries, went to those countries. In case of violation of sovereignty, the Emirates would be the first victim. If he were abducted in the UAE, there would be an incident on that soil between the UAE people and the Rwandan agent. But as I was clarified by a permanent mission envoy to the UAE in Geneva, it's a United Arab Emirates mission in United Nations Geneva. In his letter to the Secretariat of the Special Procedure Branch, that letter of 21st December 2020, it's in the dossier. That letter has reference number 0/3/32-362 of 21st December 2020. This letter says this. He, meaning RUSESABAGINA,
exactly 7:20 p.m. on 27th August 2020 on an Emirates flight from the city of Chicago in the United States of America. He was traveling alone and unaccompanied. From Dubai airport, he went to the Ibis Hotel in Dubai, where he had made a reservation. There, he met with a person holding Belgian nationality, but of Rwandan origin. At exactly 11:18 p.m. on the same day, he and the other individual checked out of the hotel and made their way to Al Maktoum International Airport of Dubai. At precisely midnight, he departed from Dubai bound for Rwanda. On bound a private aeroplane. Contrary to what is stated in the communication, he spent just 5 hours in the United Arab Emirates. The individual concerned was not held in custody. The individual concerned was not held in custody anywhere in the country and was not therefore arbitrarily deprived of liberty or placed at risk of torture. As stated, he remained in the country for just 5 hours, which he spent traveling from Dubai airport to the hotel. Then, after a brief period from the hotel to Al Maktoum International Airport, where he departed.
Your Honor, honorable judges, it's clear from this letter written by the leadership of that country, it clarifies that the so-called kidnapping it never happened. This RUSESABAGINA Paul arrived in that country from the US and spent a few hours in transit on his way to another destination. They also clarify that in that country he was never detained or tortured, as some media have purported, as it's said in some media and communications. Your Honor, this proves that that country would be the first victim if there had been any violation of sovereignty. They clarify that nothing happened to RUSESABAGINA. He was just a traveler, a passenger transiting in that country to a destination somewhere else. So, Your Honor, all this is evidence that RUSESABAGINA, when he was in Dubai, he was not kidnapped. Never. Because should he have been kidnapped, the first victim would be the United Arab Emirates, because that country would have been violated. That's what constitutes, among other things, the act of kidnapping. That country would be complaining, but this country clarifies that this individual transited in that country in a proper way. Your Honor, Rusesabagina's statement, which is confirmed by the letter by a representative of the United Arab Emirates, proves clearly, it proves that how he left Dubai did not involve any use of force. And it also, this letter, the letter from the United Arab Emirates, a statement by Nyamwongere Constantine, who accompanied him from Dubai to Kigali, in his own report, when he was being interrogated by the Investigation Bureau on 28th August 2020, on the second answer, he was asked, Constantine Nyamwongere was asked, how he met Rusesabagina and how they left Dubai together. He answered as follows. He said, this month of August, all of August, we were in touch over the phone and via WhatsApp because we had a plan to go to Burundi together. We agreed we would link up in Dubai and then travel to Burundi together. Paul Rusesabagina asked me to come with me home to Burundi because he was not familiar with that country, because he intended to visit his army, the Force de Libération Nationale, FLN, based in Burundi, who operate from Burundi, led by Brigadier General Jeva. Brigadier General Jeva, Your Honor, is mentioned in this case. He's not accused in this case, but he's mentioned as one of the high-ranking officers of the FLN armed group whose actions involved causing insecurity in Rwanda. FLN is an affiliate of MRCD. Well, you're not going to spend too much time on that. I was trying to just to mention that to give more context. He was on his way to visit his FLN, led by Brigadier General Jeva, and also meet with some of the top leaders of Burundi. He told me that he was not familiar with Burundi, and he asked me to come with him, and I accepted. On 26th August 2020, Rusesabagina Paul left San Antonio and told me we would meet in Dubai. Then, on that date, 26 August 2020, I left Kenya, where I was, and flew to Dubai, spent a night at Ibis Hotel, and waited for him on 27th August 2020. He found me in Dubai. We went to the hotel together. He took a shower, and we checked out at 10 p.m. Just the two of us went to another airport to board a private jet. That's when we flew out to Rwanda. But Rusesabagina was thinking that we were flying to Burundi. This is a statement by Nyamwongere, who explains how the trip from Dubai to Kigali, that there was no use of force. The court also asked, it wasn't anything else used, maybe? There is. My colleague will clarify that. But this statement corroborates what's in Rusesabagina's statement himself when he was interrogated by the court. Same in his statement on 21st March, where he says, when he explains how he left San Antonio, where he lived, until he arrived in Kigali. He explains his itinerary from San Antonio to Kigali via Dubai. And nowhere does Rusesabagina mention that there was use of force for him to be here in Rwanda. Your Honor, this proves that what happened to Rusesabagina was not kidnapping. And as we've clarified, in that letter written by the permanent mission representative of the UAE in Geneva, the content of that letter confirmed is the same as Niyomongere's statement, except it's the same, and it's the same, except the reason for Rusesabagina's trip to Burundi, because Rusesabagina says he was on his way to give a talk at Bishop Constantine's churches. That's what he says. But he is not an evangelist. Remember that. Rusesabagina is not an evangelist, but Constantine says Rusesabagina was going to Burundi to visit his FLN armed group and also to meet the Burundian top government officials. Your Honor, for this reason behind Rusesabagina's trip, they differ on that reason of his trip. The prosecution wants to prove that Constantine's version is the correct version because of the evidence that exists, that we have. The reason for his trip, well, he pretends he was on an evangelistic mission to Constantine's churches, but Constantine himself says Rusesabagina was going to Burundi to visit his FLN fighters. Let's clarify that. Since a long time, this Rusesabagina Paul was trying to meet top Burundian government officials, and this is confirmed that when he was searched, when he was searched while in Belgium, Belgian police found his laptop and saw different letters written at different times requesting an appointment with Burundian government officials. And some of those letters from that computer, Rusesabagina's computer, aren't we diverging? We were trying to know how he left his residence and to arrive here in Rwanda. It's related. Please don't take too much. He says he was hijacked, he was kidnapped in Burundi. So you need to comment on that. I'll be brief, Your Honor. Thank you for reminding me that. I just wanted to show that there are two versions, Rusesabagina's and Constantine's. I wanted to prove that Constantine's version is the truth, because those letters found in his laptop, there was many requests to the ruling CFDD, ruling party in Burundi. You have those letters in the dossier, Your Honor, and that proves that he was going to Burundi to meet his FLN fighters. So the other one was helping to coordinate with those meetings with the fighters and the Burundian leaders. Your Honor, in those letters, you can see that the one that dates 9th May 2017, Rusesabagina Paul wrote to the Burundian president requesting for an appointment. Another letter of 19th October 2018, he wrote to the Secretary General of CNDD ruling party asking for an appointment. The then Secretary General of CNFDD then became president of Burundi. Now, it's obvious that his activities, if you look at these letters, if you look at Constantine's statement, Rusesabagina was not in Burundi to evangelize. He's not an evangelist. He was in Burundi to meet the FLN fighters and Burundian fighters, asking for their assistance to facilitate their activities to cause insecurity in Rwanda. Your Honor, honorable judges, Rusesabagina's statement about how he arrived in Rwanda, as we've been commenting, you see these letters he wrote, and the letter from the UAE official, Constantine's statement, Rusesabagina's statement himself. All of those elements prove that there was no kidnapping, and especially that the kidnapping in its definition involves use of force. And these elements, this evidence shows that there was no use of force. Your Honor, the fact that Rusesabagina says that he was kidnapped, and he tells the court, and he cannot prove to the court, he cannot prove that he was kidnapped. He does not say who kidnapped him. He does not establish that there was use of force in his being brought to Rwanda. That proves that what he's alleging is baseless, because Article 3 of law about evidence in trials, Article 15/2014 of 12 June 2014 about evidence in trials. It says this: every party has the responsibility to prove what he's alleging. Now, Rusesabagina in his defense says there was kidnapping, but they don't prove how he was kidnapped. They don't present any evidence. What they are alleging is baseless. Your Honor, honorable judges, in his argument, Rusesabagina in his defense, they say that what the court said and what the scholars say, Scholar Sheriff Batumi and the court judges, the court's decision. The court asked him to how the relation between those two. We'd like to mention something about that and let it be on record. When you refer to jurisprudence, you clarify the relationship with the trial, with the case at hand, with evidence. However, in all jurisprudence he has referred to, nowhere does he say, well, on this case, here were the facts. This is what happened to this individual. And then if we compare it to what happened to him, it's the same thing. Here are the laws, here is the sanction. There is no single case that he has applied to his case, even though it's in the system. But in his pleadings, he does not show the case, how that jurisprudence in its paragraph, what happened to an individual is similar to what happened to RUSESABAGINA for reason A, B, C, D. Here is what the court, how the court rules, so make the same ruling. He does not do that.
Yeah, you know, he mentioned Southern African countries and the UK. I said the cases were similar. Yes, sir. But first of all, you have to look at the facts. In the English version and in the French version, they are different. It's like they have made those courts say what they didn't actually say. You know, they read into the judgments. So, South Africa, for example, and also the UK case, RUSESABAGINA, and he explained it very well when he said that the British police went to South Africa, kidnapped a man, put him on a plane they had brought, and took him to the UK. And the UK court say they have no competence, and that's what they said. Just no competence. First, the case was the same. There was no kidnapping. And also, since the British police violated South African sovereignty, they stole him, they kidnapped him, took him to the UK. This is a case of kidnapping, it's a fact. But was any Rwandan police or any security police of Rwanda in America or in the Emirates to seize forcibly RUSESABAGINA and brought him to Kigali by force? Therefore, thus jurisprudence does not work because the case is not the same. Also, the facts are very different. None of this happened to RUSESABAGINA, and in any case, even what they are being tried for, the South African case, is nothing to do with RUSESABAGINA's case. And the court in the UK declared itself incompetence, whereas here what is being asked is main levée. They're asking to be released. He's asking to be released. And therefore, neither the case, the cases are not the same. Neither by the kidnapping part or what was requested of the court or any other. There's nothing in common between the two cases. But what they should do, if they look for proper precedents, they will say, this court, this is the judgment, these are the facts, paragraph this and that. And and then they should say in the decision or the proceedings or the decisions or the ruling, paragraph this or in this, there are no commonalities. Yes, I think you're belaboring the point. We got the point, says the president. Okay, so sir, the 7 cases that were entered into the system, the first 7, see the document that we submitted asking for asking for a ruling on the competence or jurisprudence on the competence. So when you are asking a question of competence, a ruling on competence, you have gone far ahead. You can no longer come back and intervene on preliminary issues like this. Okay. So one other point, or rather, I summarize. We have shown that Rusesabagina, yes, we are, don't repeat that. We understand he was not kidnapped. Okay, Mr. President, what we want to show is that although he was not kidnapped, he said he was kidnapped. He wasn't, but I said he was. But even if he had been kidnapped, had he been kidnapped, would he be asking for release? That's release. Pure and simple. Adolf Eichmann, at the District Court of Jerusalem, but have you, by the way, there is a footnote, it's an extract. Have you submitted that whole case, the Eichmann? I think, Mr. President, I think we have something in the system, but we cannot. No. What do you, we know the case. We don't need the document. What do you want to prove with this case, the Eichmann case? Well, Mr. President, the ruling. Let me read something with your permission.
Is that the court will not enter into examination of its question. The uniform rule is that the court will not enter into examination of this question, which is not relevant to the trial of the accused. The ratio of this ruling is that the right to plead violation of sovereignty of a state is the exclusive right of that state.
So this is what I want to say. Eichmann had been brought from Argentina to Israel to be tried. I said during the trial that he cannot be tried by that court because he was kidnapped. The court said that he cannot raise those objections because the violation of the sovereignty of a country is a matter of the country that was violated, and not individuals who complain about it. If Rusesabagina had been kidnapped, the sovereignty of the country, that is United Arab Emirates, would have been complaining, saying, well, you see, my country was, my sovereignty, I want relief in such and such a forum, legal forum. Well, that's not the case. So the person who says he is a victim of kidnapping cannot plead on behalf of the country. If the country was not violated, it wasn't, or whether it was, and the country will raise the issue itself. Now, concerning the ICTY, the Tribunal for Yugoslavia, Mnichich. Yeah. Now, look, says the president. It is obvious that these precedents may be interesting, but you have to say exactly what is connected. What is the connection? Because Ashman, it was for genocide. RUSESABAGINA is not for genocide. Where is the link? There, please specify why you cite that. You understand? So because you understand what I'm reading, says the president. You have to show what is relevant. Thank you. Yes, sir. This is the principal. The principal argument is that there was no kidnapping. Then we say, if even in case of kidnapping, in other cases, decisions were taken in other courts, and they show that the kidnapping, when there is a violation of sovereignty that is concerned, the country complains. So, Mlachich, well, it was a genocide, of course, or rather a very serious case, a crime against humanity. We're not linking that now. We're just saying that whether he was, that Mlachich was kidnapped, but he was not released. He was not released. Okay, well, we get the point. We get the point. You say, in case, you had said, if he had been kidnapped, he would not have been released anyway. That's what you say. Okay, so, but we get the point. All right, I think you have concluded, haven't you? So, we hear the third person. Thank you. Yes, Mr. President. As regards the relationship between these cases and RUSESABAGINA's case, especially where the crimes that they are accused of are different. One, we use this precedent to show two things, which also tie in with the issue that there was no abduction. One principle that came through these precedents, it shows that RUSESABAGINA was not abducted. That's one thing. As my colleague had just said, there was a case where there was kidnapping, actual kidnapping, and the sovereignty of a country was violated, and the principle, therefore, from these two cases that my colleague cited, is that the first victim is not the person, but the country whose foreign sovereignty was violated. So the person has no, an individual has no standing on this. The victim is a country whose sovereignty was violated, and they are the ones to demand justice. We were saying, therefore, that up to now, no country, so far as we know, has complained that their sovereignty has been violated in connection with Mr. RUSESABAGINA's case. Therefore, there was no kidnapping. Second, as it had been shown in these precedent cases, RUSESABAGINA said he was kidnapped. And he's asking for his provisional imprisonment to be rescinded. As a matter of fact, through these precedents, it shows also that not only these individuals had no right and could not have rights to claim kidnapping when the country whose sovereignty is supposed to have been violated have not complained. Second, this cannot have any consequence or consequent effects on the case of the individual. So you're saying, madam, that if a country has not complained of violation of sovereignty, the individual has no subjective rights to claim, has no... Take, for example, the Eichmann case. There was nothing that was said about his subjective or the rights of the subject, let's say. Well, you know, Mr. Chairman, this comes from the objective rights. There is no case that was brought here as a precedent where RUSESABAGINA was deprived of his case. Yes, I understand the chair says. The precedent that you gave, Mr. The courts or the cases that you cited, either Eichmann or Mlajic, that the people had their individual rights as subjective rights. No, Mr. President, because these are two different things. You cannot confuse the two. Right, let's conclude. I think we've been very long. What we want to see is that the ICTY, for example, in the case of Mlajic,
which the tribunal orders to proved an illegal nature of his arrest, this would in no way affect the legality of his detention. In other words, even if the accused was male captus, he is in any case bene detentus.
So then, even if he was kidnapped, male captus, but if the process was illegal, then he will be in prison correctly or fairly. He may have been arrested badly, but if he was properly tried, then that's okay. So in any case, RUSESABAGINA was not kidnapped. Even where people have been kidnapped, the sanctions have never been the simple annulment of his process and his... It wasn't just as simple. Thank you. Mr. President, Your Honor, honorable judges, we want to raise one point about a name that was very frequently mentioned on both sides, defense and prosecution, Bishop Constantine Niemwungeri. As it has been said, this man is said to have been to have come with Mr. RUSESABAGINA from where he was kidnapped. He was supposed to be kidnapped. Well, you see, we had asked the court to admit the evidence of one witness. We wish to make this request, to reiterate this request, because the issue that is being debated today would benefit the process that, or this witness will benefit the process, especially for the trip for Dubai, Kigali. was with this man, with RUSESABAGINA, and on both sides, I think we would benefit if we could know exactly how RUSESABAGINA got here. So we would like the court to authorize the hearing of this witness, and I think we will greatly benefit from his witness. Thank you. So, do you want him to be brought before or after your argumentation, after your deliberate? Well, we think he should come earlier or before. I see RUSESABAGINA is asking for the floor. Do you want to speak about? You can come with your lawyer and make your point. Yes, it's about this witness. The witness, they kept mentioning, that is Bishop, or perhaps he's a diplomat or an apostle, as he calls himself. This person, I will have nothing to do with him. He is a man who kidnapped me. I sued him in Arusha, in Belgium, because his passport, he also has a Belgian passport. I don't agree. But I can't see how he can be a witness if he's the one who kidnapped me. Mr. Rudachemu. No. Thank you. I think what my client says is well-founded. If we have a case against this man, I don't see how he can be a witness. No, we are not talking about, anything about condemnation. It's what you say. He's not accusing you at all. He's not accusing you. He's simply explaining the process of how you came. So go on, please. You don't talk about accusing, because nobody has accused anybody. Yes, accused or defense. No. So he's not an expert. We are at the legal stage. We are examining the laws, points of law. He's not a lawyer, so I don't see the point of his coming here. We're still dealing with procedures, the legal aspects, what laws were applied and not. We are not in the actual judgment, or rather the actual trial. So I don't know, is he a special lawyer to see whether no law was breached? Because if he's not coming to say whether laws were breached, I don't see his present. What is listen? What law would be broken at the stage of the procedure if somebody comes as a witness to explain a process? Well, he was not mentioned before. Should have mentioned him before, so that we know him. Or we look into his background. We can even cross-examine him, rather. So you cannot just, drop him on us like that, you know, like spring him on us, it is against our rights. Because you should have mentioned this witness before, explain why you were calling him as a witness, so that we also prepare, so that we can do a counter cross-examination. We haven't researched him, we don't know his background. You are not planning to violate anything, says the prayer. We are just asking for your opinion. Oh, they should have said that. Why didn't they put it in the system? A letter. Say why they want him, what he will do, what sort of witness he will give, what information, so that we can also do our proper background research and be in a position maybe also to ask him questions. So I think this is against our rights, a violation of our defense rights. Thank you. Nyomungeri Constantin, you yourself spoke about him. You yourselves. You say that he met Paul RUSESABAGINA, and everybody talks about that. You know, the defense, accusation. Everybody has been talking about this man. So what we wanted was for him to be able to confirm what has been said during these proceedings. You mentioned him. He was mentioned many times. He has a statement that you have seen. Yes, he is the president. On page 4 of your statement, you mentioned him a lot. The prosecution also mentioned him. So where is your problem, RUSESABAGINA? Where is your problem? Can you explain? Thank you, sir. I think it will be biased. I have complained that he is the one who kidnapped me. In fact, there is a court case. And then he comes to another court case that has nothing to do with him. I haven't accused him. And he comes as a witness. I don't think so. I don't think it will be fair. It will be biased. If he has any testimony to give, why doesn't he come in the court case where I have accused him? Because there is a court case between him and me. Then another one, another case where the prosecution is accusing me. Why do you bring him here? Bring him in the other case, my own case. Don't see why he should be brought in this one. Thank you. Prosecution. But just a moment. Where have you accused him? In Brussels? Where? It's a Brussels lower court, or first instance court. The second one is Arusha. Arusha means what? Human Rights Tribunal. Accusing him of kidnapping. So I don't see why he should go to other cases. RUSESABAGINA has made his point. There are 3 things. RUSESABAGINA says he's already has a court case with him, and you can't bring him here because he has another court case. Then his lawyer said you didn't give them notice so that they prepare his background for counter, for cross-examination. Thank you very much. Thank you. Well, we'll answer these questions in the manner that is obvious based on what they say. First, there are other court cases, 2 court cases. We are not aware of these 2 court cases. And the way he said it, we have no proof that these are actual cases. But even if they were cases, there's nothing, no reason that prevents a witness from being heard simply because he has other cases with other people or with the accused, but in other places. Okay, so what we just want is a witness to explain what happened. So unless there is any other objection, we request that he be heard today. Mr. President, what Mr. Rudachema said about notice, should have mentioned it in the letter. We shouldn't spring him on them. They must do background research. There is no law that says that they have to do a background check on witnesses. They can do it, not prevented, but there is no strict law that says, there's no law that gives them strict obligation to go and do background research. So they can't use that as an argument. Second, this is a court. We have to be honest. To say that you are surprised, it's not true. This witness, in all the documents from this court, he's mentioned everywhere. Whenever we've had in whatever arguments that you'll find that this man is there, mentioned every day, even today. We've been here for a few hours only. His name, if you look at the registrar's minutes, you find that he has mentioned many times by both sides. And therefore, the statement that this witness gave during the investigation, it's already in the system since 16th October 2020. The statement is there. So you cannot then, with all this, say that you are surprised by the mention of this man as a witness. He's not foreign to this dossier. So I think this is also invalid. As regards what the court, or rather the law, provides, witness calling is provided for. It's not a matter of who wants or doesn't want what. Article 63 of the law concerning witness and evidence. It says that witness shall be called. Any witness, any person can be heard except those who are incapacitated or don't fulfill the conditions. For example, if somebody is not in a position to tell the story, if they are brought to witness, or if they are children under 14, or very elderly people, can give testimony and tell whatever they can, but without swearing, because they need support. Their witness needs to be supported by other evidence. These are the only conditions for calling in a witness. So, Your Honor, honorable judges, we think this is a sufficient argument for this lawyer, or rather for this witness to be brought, whether Mr. RUSESABAGINA or his lawyer. There's nothing that in law shows that Mr. Constantin Nyumwingere is unfit to give testimony. Article 65 of the same law about the production of witnesses and evidence, it says that if the testimony is well set out and to the point and based on the knowledge of the events and on their truthful telling of what happened, then the witness will be admitted or admissible. The court, it's up to the court to judge the fitness of a witness. And also, what is mainly examined or assessed is whether they are competent, whether their testimony is well explained and cogently told, say, and whether it makes sense. So, Mr. President, I think this is it. Continue, please. RUSESABAGINA said that there are two court cases between him and this witness, and the witness can therefore not come to be a witness in another trial, in this trial. The law authorizes the court to assess the value on competence of a witness. It is up to the court to decide whether what is being said in witness is proper. Nobody has a right to stop a court from calling a witness, especially when you haven't even heard what this person is saying, when there is nothing disqualifying this witness from appearing. So which war? No, they are not based on a law, says the president. They are just requesting. Yes, they are requesting, but we're showing that their request legally is invalid. There is no law that supports the granting of their request. And Article 62. Yes, well, let me begin by Article 66, which says that witness, the witness has to be an eyewitness capable of telling the story as they saw it. And therefore, if this man that we want to call as witness on the 28th was with RUSESABAGINA from Dubai, and they got here, well, then he saw. He's an eyewitness. Both sides agree that this man traveled from Dubai to Kigali. So can we say that he saw nothing? He knew nothing? He heard nothing? When in fact he was with RUSESABAGINA from Dubai up to Kigali. So that you think he has nothing to say, so that the court can rule him out, rule his witness out. We think this witness is important. He's an eyewitness. He has knowledge of of what is being tried, and he knows he can, I think, be very useful as regards informing the court. So, Mr. President, to conclude on the legal points, Article 66 of the same article, it says, provides that provides the manner in which a trial can bring witnesses. So the accused can call witness, and if he comes, or the accused or the other party, if a witness comes and what he says or she says is cogent and logical and useful, then he is admitted. And there is no law that says he cannot be called to witness. So, Mr. President, we're citing this article because, it will say that they were not given enough time to do background checks on the witnesses, but it's obvious that in any case, this article makes it or demands that the witness explain cogently and is able to express themselves logically. That is the only condition. And therefore, there is no law or no legal basis to prevent that witness from coming to court and give his testimony on the topics of today, as the prosecution has asked. So preventing him from coming is not founded on any law. Thank you.
The court takes note of what you just said. This witness, Constantine Nyomongerye, was interrogated by the Investigation Bureau. He gave his testimony about how RUSESABAGINA arrived in Rwanda from Dubai. Now, the court wants to ask the prosecution if that information that you want him to share here before the court, is he likely to share something different from what you told the investigation, which is in a statement he made before the Investigation Bureau? In other words, if the witness comes before the court, is he going to share something different from what he told the investigation? Thank you, Your Honor. We cannot say that he's going to share something new or something different. We do not know what he's going to say. When witnesses before the judge, he's able to say something and answer questions from the judge. We cannot definitely tell the court what he's going to say today, but we think it's important for him to be heard by the court in addition to his statements in the dossier. We believe that because what he's shared in the statement remains controversial. Both sides do not agree on it, so it's important that he come here and then be asked questions and that he will answer. We find it necessary that if he is available, he ought to come here and be heard so he can enlighten us, enlighten both sides, thanks to the information he shared, including probably what he shared with the investigation. P. and Roberto wants to add something. Well, we were here to support her, but he said most of what we wanted to say. All right, RUSESABAGINA, want to comment on what they said? Yes, there's a lot I could say about what they just said. I want to thank you for giving me an opportunity once again to comment on what the prosecution has just said. Their witness, that witness on whom they base most of their accusation, is the one I spoke with when I was in Belgium, when I was in the US. And as he said, it's true that we spoke on WhatsApp, but everything that he told was just lies. To the point where he told me to meet in Dubai to fly together to Bujumbura, and which turned out to be a lie. He lied to me. He said I was on my way to Burundi to see my soldiers. Now, how does a person go to see his army and pay a charter flight from Dubai to Kigali instead? He's the one who planned the whole thing. Instead of me flying me to Dubai, he flew me to Kigali. He personally said I used tricks. I tricked him into coming to Rwanda. He said we sedated him. He said personally that the pilots who wanted to say that we're approaching Kigali, I told them to keep quiet. And I will explain more about that at the right time. So all that this person said was in connection. He connived with RIB. People said no Rwandan agent was present. Well, how do I know that he is not a Rwanda government agent? He says since February 2020, he started a partnership with RIB, but he had never told me that. Now, his testimony from such a liar, a traitor, he's an accomplice in kidnapping me. What kind of testimony could he bring here today? What use would it do? That's a question I'm asking the prosecution, because they're the ones insisting on bringing him to testify. Everything that he told me from the very first day we met until today was a lie, were tricks. What kind of truth could he bring here? Well, you would have had an opportunity to interrogate him. If he were here, present, you could ask all those questions, put those questions to him. For me, this is not the right time to talk about that. We will have another setting. Those other two trials, that's right. PN, you want to comment on it? Thank you, Your Honor. Let's avoid let's avoid calumny here. Why is he scared of seeing this witness here? He's the one who kept mentioning his name in all his reports. He mentioned that person when he explains what happened. Why does Paul RUSESABAGINA want his statement to be the only truth? He stops the court from hearing the witness, Your Honor. Instead, we believe Paul RUSESABAGINA's statement is a lie. Because that witness, because he's the one who had been talking with him for years, he'll be able to tell the court the gist of those conversations, the plans they had from the time he was planning to go to Bujumbura. He will clarify why he brought him to Kigali. Paul RUSESABAGINA is scared of the truth coming out. Your Honor, these reasons should not stop that witness from coming forward to tell the truth Paul Rusesabagina's party is fortunate to be able to prove what happened, to clarify what happened. But after that witness has given his testimony, they will be able to comment on what he said and set things straight. There is no basis, no legal basis they have to stop the witness from coming here. Maybe there are other trials, but there's no legal reason to stop a witness, even if he were a co-accused. There's no legal obstacle barring that person from giving his testimony, so far as it helps understand the case at hand. Because this objection about kidnapping was brought forward by Rusesabagina. So let's go to the bottom of it. They say he said he's accused that witness for having kidnapped him. Well, let this court listen, hear that witness. We've clarified this at length. We are parties, so you are the ones. The court will rule on this case. But give a chance to that witness, give Rusesabagina a chance to give his testimony, then the court will rule. Thank you, Your Honor. Mr. Rusesabagina, you want to comment on that? Even if he were your co-accused, like these ones here, there's no legal reason he could be stopped from giving his testimony here. Nothing. So what's your comment on it? Does your lawyer want to comment on it? Like I said, that individual, as Prosecutor Robergo said, I don't want to this back and forth between the two of us, but I have rejected the very idea of bringing that witness to this case because I have a case with him, other cases with him. I took him before two other courts. How could he come to testify in my case here? That would be contrary to professionalism, because people should be at ease as they make their pleadings. So he has been collaborating with the investigation, and he participated in this whole thing. I will not spend too much time on it. I don't see anything new he's likely to bring forward that he did not tell the prosecution before, that he is likely to surprise us with here today. Well, as far as I'm concerned, he has done nothing good to me. I don't see him bringing anything positive to this trial. I want to see him in the other two tribunals. So I don't see why I should be facing him here or hearing him giving his testimony here. I don't want him here in this case. I'll see him in another tribunal. You have a lawyer. So can he reject that witness? Based on what law? Can you explain that? Apart from what Rusesabagina said, his concerns that that individual is the origin of his plight. So what are the legal basis for that? We understand Rusesabagina's concerns, but legally, what are the obstacles for us to hear this witness? Thank you, Your Honor. Thank you, honorable judges. Before I talk about the legal basis for this, I'd like to request the prosecution to avoid calumny. The prosecution says RUSESABAGINA is the one who's lying. They say RUSESABAGINA is scared of the truth coming out. That's, well, if that was used, if it's used again, we will stop the prosecution from using such kind of talk. He is still innocent so long as he is not yet convicted. If it happens again, we'll stop it. Thank you, Your Honor. My client has expressed his concerns about that witness. And like you said, even though I don't have the law right here in front of me, when you have concerns about a witness, when you have an issue with the witness, like what the client has said, then the court appreciates his concerns and the validity of his concerns. We cannot spend too much time on it, but he did not know he was going to hear the witness being called to the stand today. So, Your Honor, I believe my client's concerns are enough to stop that witness from coming here to give his testimony when they still have issues. He has an issue with him. So I hope the court will decide, will rule on that. Thank you. Thank you too. Please take your seats. My colleagues tell me that there was another co-accused who wanted to make a comment. If there's anybody who wants to comment, Maître Fidel wants to make a comment, go ahead. Before we take a few moments to make a decision. Thank you, Your Honor. I've followed this debate about the witness who was going to give his testimony in this trial. And I've focused on Article 71 of governing their evidence in Rwanda. So let me talk about that article so you can examine it, because this article can help decide. It says this: any witness who could facilitate the trial will say what they know. The court cannot stop a witness, a key witness, to say what they know about the trial, about the case, and the parties cannot reject the idea of bringing that witness. All that the parties can say or comment on is the reason why they believe the witness would not tell the truth. I'm sharing this article, Your Honor, because the point being debated on is because this individual's testimony is key. Because what happened to RUSESABAGINA, nobody knows it better than the individual who was with him. And about rejecting that witness, this article says no party has that right to reject the witness. They can only explain why they believe the individual would not tell the truth. Then it's up to, well, the court cannot stop him from giving his testimony, but they can they can analyze the testimony given. Well, Rusesabagina was saying that he's not an attorney. Well, he used those words, but he was expressing his concerns, just like you said. He gave his reasons. That's the context. So that's why we gave his lawyer to say what legal basis he thinks stopped this witness from coming here to give his testimony. So what's your stand? For us, this individual is key. He's very important because he knows what he's talking about, and his testimony would give answers to many questions raised in this trial. Thank you, Your Honor. Thank you too. Maitre Rudakemwa, if you want to make a comment, you have the floor. If you don't, the judges will take a few moments and make a ruling. Do you want to make a comment? Go ahead, Paul Rusesabagina. Thank you very much, Your Honor. What Maître Fidel just said is about normal circumstances. Under normal circumstances, it's not about the case where you have a person he's coming to prosecute you. Well, he's giving his witness, but it's against me. So he says things. And like I said earlier, let me repeat this. Whatever testimony he is likely to give is no different from what he did to me from the moment we met until today. And that's why I took him to court. Thank you. Thank you too. Do you want to add anything? All right, go ahead and take your seats. All right, we'll suspend the proceedings about 15 minutes so we can consult before we make a ruling.
urukiko.
Bicare. Iburanisha ryari risubitswe rirasubukuwe.
The court resumes. This is we want to give the ruling that was made as regards the witness and what Mr. RUSESABAGINA said. But I think the prison administration says that we have to conclude at by 4. So I think we want to finish by 4. Is everybody agreed? 4 is okay? Thank you. So this is the decision of the ruling. For the rest, we shall proceed. My colleague will read the decision of the ruling. Having heard the prosecution requesting that a witness who is familiar with the way Mr. RUSESABAGINA came to Rwanda, the witness is Constantin Niyombwungere. Given that he's the only one who knows how RUSESABAGINA came from Dubai to Rwanda, having had RUSESABAGINA and his lawyer say that they do not wish him to come as witness because RUSESABAGINA has sued him in other courts, and also because he had a hand in his kidnapping. Having heard Mr. Mugabo Fidel saying that you cannot recuse a witness, and because the witness comes, the only thing you can do is to show that what he says is not true and provide proof. It is a court that judges. Therefore, there is nothing to prevent any witness who has information on the case, especially if he or she is likely to provide useful information on what actually happened. Given that Mr. RUSESABAGINA has objected, therefore, he will not testify as a witness under oath. He will just come as a witness to give information as to how this happened, how RUSESABAGINA came to Rwanda, because he is the only one who has the full information. Thank you. This is the decision or the ruling. I don't know if the witness is nearby. He may come in. We'll ask him as questions as a witness, but not under oath. He will give information only. Thank you, Your Honor, honorable judges. I see that the court will not hear Constantin Niyombwungere as a sworn witness, but as someone who will provide additional information. Mr. President, if this witness is to be a question not under oath, what other information Do you need over and above the three statements that the witness gave? Please, this is a ruling. You are not going to challenge the ruling. You're just going to express your views. Article 71 says that the witness, let me read it. Says that an accused may give the reason why they think the witness will not testify in their favor, or will not be truthful. Therefore, my client has shown that this witness will not be truthful, and the court found it to be so. But now, so you say that you want to ask him for information. What is the use? The court will appreciate, sir. This is the ruling. These are the law. This is the law. The court always appreciates or determines the validity. Yes, I'm a lawyer, sir, but no, don't worry. If your client is apprehensive of this witness, all the more reason why he will come and testify, but not under oath. So, and the court will appreciate. This is the law. And we are not going to debate the ruling, sir. I thought maybe you had another item, but if you're coming now to challenge the ruling, you are a lawyer. But RUSESABAGINA can say something. Well, Mr. President, I wanted to say that if they want to hear, let them come. Let him come. If that's what you decided, I think it's fine. But Article 71 says that there are witness, or rather one of the parties can recuse the witness. Yes, you have said, you have made that point. You have made that point, and we thought it was very important, and that's why we decided to hear him not under oath. Okay, just as an informant. All right, and so we shall not call him witness. We'll call him informant. Good afternoon. Can you present yourself, please? Your name? Constantino Mungere. Your parents? Nzugize Francois is my father. Your mother? Yamuremye Beata. Your date of birth? 10 July. 10 June 1976. Where is your address? If you live in Rwanda, give us your address, the full address. And if you are in another place, you give us your full address. I do not live in Rwanda, sir. I live in Belgium. I visit Rwanda in the course of my work. But, so where do you live? Commune Forêt in Brussels.
asubiriremo atuye mu Bubiligi.
Give your full address. I just wanted to make sure. The Forêt Commune in Brussels.
Okay. Urubanza.
Thank you. There is a court case, as you see. Rusesabagina and co-accused, and the court wishes to be a witness for the prosecution, and but we thought that perhaps you should testify as an informant rather than a sworn witness. So can you explain very clearly and in details how Mr. Rusesabagina came to arrive in Rwanda? Thank you, Mr. President. That is that information will be given, but I think I should start with how we met, not just how we arrived in Kigali. If your permission, oh yes, we need those details. Thank you very much. Now, so speak a bit closer to the microphone, and don't speak too fast because we have a registrar and they need to get your point clearly. Thank you. Thank you, Constantino Mungere is my name. I am a bishop. Musenyeri in Kinyarwanda. And I met Paul Rusesabagina in 2017 in Belgium through a common friend. The day I met him, Mr. Rusesabagina, we spoke. Our friend introduced us. He explained who I was, and then he explained to me who this gentleman Rusesabagina was. And he said he has a reason for getting me to meet Paul. So Paul took the floor and explained to me that he's the chairman of a political party, MLTD, an opposition party, and he had an armed group, FLN, and we spoke for a while. And then he said, well, look, I understand you are a bishop and in the Great Lakes area. Can you help me? Because I want to get in touch with the Burundi leaders. I have a number of things that I wish them to facilitate for me, and if I can make them. So I spoke to the person who is introduced us. I said, well, I don't know that I can help you, but I can introduce you to somebody who can perhaps get you to government, into government circles. Okay, so in a few days, just a moment. You met, when did you meet? 2017. I don't remember the month, unfortunately. So after a while, I introduced him to someone who worked at the embassy so that they can talk. I told him that my work doesn't meet at all with politics and politicians. So I introduced him to this person at the embassy. Then we spoke. I spoke to Paul from time to time on WhatsApp, and so on telephone or an email. There is even a time that I went to his home, twice in fact I went to his home. And then one day I read on the internet, I used to follow BBC News, and I heard that in Rwanda there were deaths, people have been killed. And then they said they might sit there, and they fell in the news. And there were other messages that came, people, you are in groups and people send you info. So I sent a short message to Paul RUSESABAGINA. I said, but what's all this? And he said, no, those boys. These, no, I said, are these your people? I said, are these your people? He said, yes. And I was a bit afraid, as a bishop, to have been talking to somebody of that sort. And I said, well, I have to get this clear. So I asked him, I said, Rusesa, did you really say that these are your people who did this? He said, no, you see, no. Monsignor, no, really, my worry is not that people have died. My worry is that when they killed him, Sankara went on the radio and claimed that they did it. So I said, oh, well, so they did it. Why didn't you want him to say so, to claim the fact? And RUSESABAGINA said, no, they should have done it and then kept quiet. So that if it's necessary, maybe we put it through social media, that it is the Rwandan authorities that did it. This is what we wanted. It's usually it facilitates the work of getting the country to revolt, take up arms if the government is persecuting them. So I said, well, I think I made a mistake. I think I should, stop all contact with this man. And what I didn't like, what I hated the most, is that you ask somebody, and these people have died, and he said, oh, we killed them. I said, but why did you kill your countrymen? And he said, oh, that's not my problem. The problem is that this Sankara, spokesman went on the radio and claimed these killings. He should have said something else, because he shouldn't have said. But then I was shocked, really. I was shocked, because my job, what I have been consecrated for, was to help people and not to do these sort of things. And I'm a man of peace and compassion. So I went on speaking to me. Just a moment. You went. No, it was on telephone or WhatsApp. As little as possible, because I had a problem. I even asked God why he allowed me to meet a man of this sort. Because, okay, a political party is okay. It's no problem. But I said to somebody, these people died. He said, we killed them. And then he said, well, that's not my problem. My problem is that they die, okay? And then this Sankara fellow accepts it and claims that, and when we could have used it for something else. So I said, this man is not somebody I should continue to talk. Okay, when he wrote, I would answer vaguely. Sometimes I didn't cut, relations. But I had started studying his case, wondering what sort of man he is. Anyway. But, the relations got sort of disconnected. Then I came to Rwanda, It was in around 27th February. 27th February. I'm sorry, I think the dates I have to verify. But it was in February. And somebody called me on the phone. Person introduced themselves, but he didn't say what he was. But he was from RIB, Rwanda Investigation Bureau. And he said, well, I have a friend in Brussels. Can you take some little thing for him, please? Do you mind? I said, no. So I went to meet him. He said, where do we meet? I said, well, we'll meet wherever you want. He said, no. Please, it's just something very small. So I went. We had a driver. We went to where he said we'll meet. And he gave me, he said he was going to give me the parcel, small parcel, plus a friend. And then when I got to the meeting point, people came and they came out of a car. They said, but you said you had a message. I said, no, come, we'll take you somewhere. Yeah, so he took me to an office. I will go to RIB, and he asked me a number of questions, including about RUSESABAGINA. And he said, well, these are the signs you are in contact with him. Well, I couldn't say no, of course. I said, yeah, I do. But I said, but can you call him? I called him from RIB office. Well, he didn't know, of course. I said, where are you? I said, how are you? He said, oh, where are you? He said, I'm in America. And so anyway, so that's what happened. And then the following day, so I went, and the following day, I went back. Michel, I don't remember the other name. Michel is a man who spoke to me more frequently. He asked me questions. He said, well, you see, now what happens? You are here because you are suspected of working with terrorist groups. Oh, I was so shocked. Imagine a bishop accused of working with the terrorists. He said, no, don't worry. I will show you signs, proof. What I have said, what happened, who said what, when. And he asked me when they met. And he said, well, RUSESABAGINA is this, he has a party. Did you know? I said, yeah, he told me. He has this group and that. I said, yeah, he told me. So therefore, you are in a league with him. So I came up, brought out everything. I explained that we are not together working on that side. So he said, did you know that people were killed? And so I said, well, I heard, and this is what this man told me. And from that time, I stopped contact with him. Well, he does call me, but really disconnected or more or less. Okay, so they will come and ask me questions. I show them what I do in Africa, my various projects, to prove that what I do in Rwanda and other countries has nothing to do with terrorism. That in any case, if I had been in league with these people and I had killed Rwandans, obviously I wouldn't have come to Rwanda. And I think after 5 days, Michel said, well, look, okay, so now you can do whatever you want. What do you want to do? I said, if you let me free, free of my movements, I will close any contact with RUSESABAGINA. I will not speak to him anymore. He said, no. We got we understand that you are not connected with him, but you can help us to follow this man so that you can help us prevent any future crimes. Oh, I said, well, okay, I accepted. I wasn't very assured, but I didn't feel very good, but I accepted. Now, let me go back a bit. They showed me the kid, the photographs of the damage they had done, the killings, the children who were orphans, the widows. And I was very upset, really, to have met a man who commits such things and who is happy. I had never in my life met a man at all who was glad that people have died. So this is what happened. So I went on with him because well, that's what it is. And then I asked him when he contacted me. I said, I'm going to Burundi. And he said, are we going to Burundi together? If you're going to Burundi, can I go with you? I said, well, I don't know. Because I was in Kenya at the time. I wasn't in Europe. I was on my other projects in Kenya. I said, well, if you want, we can see when I can be available to take you to Burundi. I'm sure you can manage that. Then, of course, I called Michelle. I said, well, look, Michelle, the man, yeah, you remember that the man is the one who works with me. I said, well, that man wants to go to Burundi, and he says that he wants me to go with him. When is it, more or less? I think in 2020. It must have been July or August, between July and August. So he's going to Burundi. What's he going to do there? To ask him. So I asked him, so how are you planning? What do you want to do, etc. He told me all the problems he has. His party has a problem, many problems, and his fighters also have problems. Those who were in Congo, many have been arrested. The others fled to the southern Kivu and even Burundi. I say that their leadership is not working well. They now have a misunderstanding between them. He told me everything, and I told Michelle in turn. And Michelle, yeah, he said, okay, you go, but I can tell you that my heart was heavy already to have to talk to him. And then because up to that time I had never even been called to a police station, and now there is this man from RIB who has to give me permission to go here, to go there. He said, well, don't worry, you go there, you go with him and learn as much as you can. I said, oh, because you see, communication, as a bishop, 5 days that I am away from my work. And then if it turns out that 5 days I'll be with soldiers and terrorists, and so you wrote to Michelle, eh? I said, look, Michelle, I don't feel right. I said something that I cannot I cannot hide this. I said, well, look, this man that you say I have to watch, the Bible tells me that you should do good if you can. Now, I know killing is, of course, wrong. But I said, Michelle, please, this killer, can you allow me to do something so that he is arrested? And that is why. So he said, why? And I said, really, even when I pray, I don't feel comfortable. I see those children, those widows, and now to have to deal with the man who caused this. So we began to prepare. He said, well, what is your idea? What do you want to do? I said, I think I should do something about him. Because instead of a man, instead of being a dog, it's better to die than to be a coward. And Michelle said, well, okay, tell me what you want to do. So I spoke to RUSESABAGINA. I said, when are you leaving? He said, well, the problem is that going to Bujumbura is a problem. Because if I take a normal, regular flight, Rwanda has sent a note, a request, I don't know how you call that technically. Anyway, they had written, yes, written an arrest warrant. I said if I take the normal car transport or normal plane, I will be arrested. So you see, you just said car. Did you mean car or plane? No, sorry. I meant regular flight. Yeah, regular flight, where there are all the Rwandans and Burundis and Kenyans in those planes. So I understood that. In fact, 99% of what encouraged me to do what I'm telling you to do, he is the one who enabled me. RUSESABAGINA is the one who enabled me, because I got to know him, because I got to know his plans, because I got to know what kind of a man he is, and I came to know his plans, and I said, now I am decided, I will act. And then he said it was a problem with traveling by plane, worse even by car. So I said, well, I told Michelle or Mike, I said, I have to act. I began my life well. I don't want to end badly. This man has got to be brought to something has to happen. So he has to be brought to justice. And so whatever he asked me, I said, well, it's possible I can take you to Burundi. And I was lying to him. I started lying to him. I said, well, the government, the authorities agree. There are people who can even pay your flight. But nobody, of course, has decided to charter a flight for him. I had never even contacted any Burundi authority. No, nobody at all. So he's here before me. He knows very well that this is the truth. When I saw what he did, I saw those orphans and those widows. I said, no, I cannot I cannot let him go. So anyway, I did everything that I had told him to arrange for his trip, and he was very happy to go to Burundi to meet his people. And he told me the names. I don't know if you want the names, but anyway, he told me the names of the important people of his group. Yes, his group. He told me the names of FLN and Rebellion and so on. But I didn't pay attention very much to that. What was important for me was to organize for him to be brought to justice. I spent a lot of nights, sleepless night planning, and I thank God to guide me in that, because we could not let this man go, because I said he has to be brought to justice. So I planned all that. I really did my best to make a good plan. And then one day I said, well, the plane I think is ready. Do you want to go through Europe or through Asia? He said, I can't go to Europe because Rwandans, he didn't tell me which ones. Justice, I don't know. He said that they're working with the police of many European countries, and they may arrest me because the contacts I've seen with the law enforcement agencies in Europe, I don't feel well. So there is an arrest warrant. So Europe is not good for me. So I said, well, what about Germany? No, he said, the whole of Europe. I said, okay, come to Kenya then. Kenya, he said, well, East Africa or Africa, I don't feel comfortable in Africa. Why don't you go to Dubai? He's the one who proposed it. I had said Asia and so on. He said, no, Dubai is okay. Dubai. Oh, so you were still in Kenya, huh? Okay. He was still in America. I was in Kenya. He said, Dubai is fine. Arab countries are fine. I even know Dubai. I've been there many times, so that's fine. Okay, so we arranged that. And when the plans had ripened, I called Michel or Mike. He said, send me a copy of the aircraft, the plane. I did. Said, I want to make sure. So I did that. But of course, he thought he was going to Burundi. But myself, I had decided in my heart that he has to be brought to justice. I did not take him to kill us. I took him to justice because I could not sleep anymore to be under, or rather in contact with somebody who kills and then said he doesn't care. So Michel sent me everything. And he had he had already paid the ticket and the passport for formalities. Why do you say Mike and then you say Michel? Is it Michel or Mike? Michel. But I think it's the same name, Michel Mike. Anyway, then I told Michel, look, this is what happened. He has sent me the ticket is there, everything is there, passport and so on. I said, don't worry, it will work. There have been there were times when I prepared something that didn't work well, but I think this will work well. Don't worry. I have prayed for it. So he said, well, I will I will give you the further news. So I told RUSESABAGINA, okay, I'm going to Dubai from Kenya to meet. I spent 2 days in Dubai. I had never been to Dubai. And when it was time to arrive for him, I went to the airport with a nice car. So, we got his luggage and so on. I took him to the hotel. I had paid the hotel. And I was upstairs. I was downstairs, but in fact he didn't spend the night there because he just took a shower. He thought he would spend the night, but I told him that the best is to travel immediately, the same day. But from that time, of course I consulted him. He said, well, you see, if I spend the night here, it will be better. I said, well, look, you see, there are Rwandans in Dubai also. They may have discovered your presence. You will sleep. So, I convinced him to go. We went. We were at Ibis. We went to another airport for a private airline, for private jets. Okay, so when we got there, we went to the VIP lounge, and special people. So we went. I asked for the passport, and then I went to a hostess. I said, "Can you stamp these? Have these passport stamps?" They gave us a visa. We are both Belgian. We had Belgian passport. There was no problem of any sort. They just stamped our passport. And the visa was not necessary. When you come from Belgium, you go to Kigali, you're given the visa at the airport. No problem. Okay, so this is what happened. So what I want to say, whatever I did, I consulted him, and I did whatever he wanted. In other words, I just, I would say I used his weaknesses, manipulated him a bit, but there was never a time when I didn't do what he wanted. For example, they brought the passport after a few minutes, and then they called us. The flight was ready. We passed through the scanner in a normal way. And the suitcases came through the belts as usual. We went out, everything was ready. When we went out, there was a car, and I said, Mr. President, as a joke, I opened, and he entered the car. I said, Mr. President, please step here. Please step forward. So we did that. Nothing else. We went to the aircraft to climb. And went into the aircraft. We boarded. But I changed a little the sitting arrangements. I didn't want him to the seat where he can see that screen that displays all the trip, where the plane has reached. So I arranged so that he doesn't see the screen, because he was going to Bujumbura, and I was going to make sure he get there. So that's what I did. When we were seated in the aircraft, Paul RUSESABAGINA, I was seated normally. A hostess came in the normal way, and as he's a bit chatty, well, I mean, okay, the flight, of course, made a message, and I know when they are going to make an announcement. When I heard, you know, the little sound that comes when the pilot is about to come onto the microphone. So I distracted Paul, you know, in a loud voice, and so that he doesn't hear what the pilot is saying, where we're going, you know, but the rest was just fasten your seatbelt, we're going from here, we'll arrive there at that time. So I distracted him. And then the hostess, as I said, came. He's a chatty man. Even on the phone, we spent many hours. He said to the girl, the young woman, tell me, from here to Bujumbura, how many hours? The girl, of course, was going to say we're not going to Bujumbura. So, but fortunately, I prayed, please God, let this woman not say that we're going to Bujumbura. And he said, from here to Kigali, so many minutes. Then to Bujumbura, so many minutes. From here to Kampala, so many. So she gave the whole range, all countries. They are close and the distance is more or less the same. So anyway, so that was that had passed, and then I said to the young woman, please bring us water. I said, Paul, aren't you tired? Let's recline and rest. So I said to the young woman, the hostess, I said, please, can you switch off the lights? Because Paul, my friend is tired. I think we need to rest. Okay, so he rested and then he fell asleep. I didn't sleep very well because I was worried. But so I couldn't sleep, really, to tell you the truth. I was awake all the time. And then they said we're going to land in Kigali. And when I heard the announcement, I looked at Paul and he was still asleep. I said, thank God, that's good. And then eventually when we arrived, we landed, I said, oh, we have arrived. He said, well, that's very interesting because that didn't take a long time. I said, no, we've arrived. So the young lady said the suitcases will be taken care of. We came, we arrived, we went out. Then Mike came, and then he showed a paper, took him in his car. I went into a different car, and that was it. That was the last time I met Paul. If anything, if there are any questions, I'll answer, sir.
Thank you. The court will ask you a few questions, starting from where you just ended. You said once we hit the ground, the airport, I saw Mike Michel and he served him his arrest warrant. Can you explain how Michel came to know the exact landing time? Yeah, I think, Michel is the one who chartered the flight, the aircraft. I don't know how he paid the flight. So he knew all the details of that flight. He was in charge of the whole operation. I told you all I did. So Michel knew everything, no doubt. You also said that he told you he's scared to travel in different African countries. He said, I wouldn't go to Nairobi. How did you win his trust that he would be fine in Bujumbura when it's also an African country? I told him it's my motherland. I told him, well, maybe you didn't get it correctly. I'm not the one who invited him. You know that. Well, we got that. We got that. We just want to understand a little more. So once I told him that he was going to Burundi, gave him all the trust he needed, but he was also in touch with the other people in Burundi who were inviting him. He also had he knew he was safe in Burundi because he was invited there. All I said is I told him that we'll find a private jet to get him there. Thank you. You also told us that he told you he had problems in his armed group. What else did you talk about? Did he talk about your churches, giving a talk at your churches? Has he ever prayed in one of your churches? He told you he had issues within his armed group in Burundi. Has he ever talked about your churches? Did you ever pray together since you were friends? Sir, well, please answer that question correctly. As part of his plan, was there anything related to giving a talk at your churches? Your Excellencies, that has nothing to do with his plan at all. Not at all. You know, my churches, you're talking about this gentleman, right? Well, ever since I met him, we have never talked about God. No, never talked about God. He never mentioned that name of God. Then how could we have talked about him coming to Burundi in godly matters? No, we've never done that. And about praying, giving a talk at my church, he's never prayed at any one of my churches. I've been watching YouTube where he says that I invited him to give a talk to my congregations in Burundi about his film. Your Excellency, please check for yourself to find out whether he has given a talk in a church anywhere in the world. I couldn't have invited him to give a talk to my church about his film. That film talks about killings that happened here. There's no reason for me to come and teach killings in Burundi. We've seen killings in Burundi ourselves. There would be no benefit in doing that. I already knew who that guy was. I was not going to pay a plane ticket for him to bring him to Burundi. You know churches, Your Excellency. He's the one who told me this private jet has cost at least $100,000 to charter it. So what church will pay $100,000 to pay for a private jet for somebody who doesn't contribute in any manner to the church, does not help the church in any way? That was a big lie. That's what I want to say briefly. I've never invited this guy. Another question is, you said that the idea to bring him to justice is your own. You're the one who is the originator of that idea. Do you mean that when the RIB agent called you, Was he worried? Was he concerned that you collaborate with the RUSESABAGINA the first time they arrested you? He was he thought you were collaborating with the RUSESABAGINA. That's right. He showed me the messages we had been exchanging, and he said some people in Belgium helped Michel to get that information, those phone records. He said, you're in touch. What are you doing? Did he express any idea? Did he ask you to help him? No. There was nothing else behind his arresting me. They arrested me, asking me, thinking I collaborate with that individual. And like I said, I've never been involved in any political activity, never belonged to a political party, nothing of the sort. What I told you is what I told RIB. I told them I didn't know anything about his activities. You told us about RUSESABAGINA's trip. You told us you're the one who crafted the idea for him to travel from America to Burundi. He paid his air ticket from America to Dubai. Is that correct? No, you got it wrong. I'm not the one who started the idea to take him to Burundi. He is the one who expressed his idea to go to Burundi and asked me to go with him. But what I did is I started the idea to bring him to Rwanda. So please understand, you need to get that right. Well, what I was saying that RUSESABAGINA is the one who had the idea to go to Burundi, paid his own air ticket from America to Dubai. And from Dubai to Burundi, he had told, did he tell you what he was going to do, how he was going to travel? I'm the one who had told him that I was in touch with Burundi officials who were going to facilitate us getting a private jet. And he said, is that so? And I said, yes. But let me repeat this. There's nowhere the Burundian government was involved. Nobody. I've never spoken to anybody in the Burundian government. I did it as I had planned. Didn't he tell you about the interest Burundian officials would have in paying him a private jet? Well, he's an adult. You can ask him about his plans, the plans he had to go to Burundi. Well, he probably had plans to talk to Burundian officials, but I know nothing about that. I told you what I did and the motives I had. But he had his own plans in Burundi. But what I did is what I told you, and I did what I should have done to make sure that this individual is brought to justice because of the pain it caused me when he told me he was behind the killing of innocent children and other people. So please repeat, who found the private jet and paid for it? I think, like I told you, the only individual I know is a guy called Michel. He told me he could find a private jet, that he will take care of it. And I said, if you can do that, then let me pray to God and plan the rest of it. And I told him, God is with me. I'll do that. Because he kept asking me, can you do that? And I said, God will help me. God is the father of all orphans. I told him, gave him all the verses, including this one that says, if you know what's good and you don't do it, then it's a sin. Because I told myself, if I do this and it helps bring justice about, then I gotta do it. So you ask the rest to Mike. He's a RIB staff. Well, we're asking you. If we want to ask anybody else, then we'll do it. So please answer the questions because it's only you here today. If we need to ask anybody else, we will. Well, the only person I know is Mike. I never paid any money to get that private jet. The person I spoke with about the plane is Mike. Last question from me. And that private jet, was there any other passenger? No, it's a private jet. It was only me and this gentleman, Paul. The other person was the air hostess who was bringing us drinks and serving us. And then there was a pilot, maybe one or two, I don't know, in the cabin, in the cockpit. But the only passengers were me and Paul. He knows it. There was only two of us. So the plane's itinerary for the pilots to know that they were going to Kigali or Burundi, who gave that itinerary? Is it you? Was it somebody else? Your Excellency, I knew I was flying to Kigali. The RIB contact knew I was coming to Kigali. The only person who didn't know they were going to Kigali is the gentleman, Paul. Even the pilots knew they were flying to Kigali. But who told the pilots and the plane that you were going to Kigali? I don't know. I don't know. And about payment of that private jet, when did you know that? When did you find out that it was paid for? Well, I found out that very day in the morning. Paul was on his way. So who told you about that? Well, I was told by Mike. But knowing how it was paid, the cost, did you know? No, I know nothing about that. Well, I found out the plane was ready for us because I did that over a month and a half, and all the time praying to God, so He helped me and guide me. I told Mike about what was happening and told me, don't worry about the plane. So, planning that operation, how long did it take? Did you talk to RUSESABAGINA? How many times did you talk with him? Well, about that operation, I told you that whatever RUSESABAGINA told me is what I used. He gave me the information I used to plan this operation over a month and a half. But I think it's a month and a few days. We kept planning and we kept refining this, and he knows what we did. I can't say everything here. When the time comes, when it's necessary, I will tell you more. But what I wanted to do was to show you my role in this. What are the things that you're saying you will not tell us? Well, he will tell you himself. He's been talking about on the radio that he was coming to preach in Burundi, and I deny that. Then he will explain to you what kind of preaching he was about to make. You told you that once you found out that people were killed in those FLN attacks, you almost stopped dealing with RUSESABAGINA. Now, except for the trip, how many times did you talk with him before that trip? Your Excellency, please understand this. There is, well, I mean contact, not I meant contact. Well, before that planning, we would talk, just small talk, greetings, way before then. But after that, once I found out what he was doing, I started trying to find out exactly who he was, what he was doing, even before Reeb arrested me. Because I came to find out that according to Belgian law, I was going to be in trouble if they were to find out about the contact I had with him. Because it's not easy to hide that. You know, what they had publicly said that they had done, the whole world knew. So after I found out what they were up to, I really reduced the number of times we would talk. If I did, it was for a certain purpose. Now, when he told you he was planning to go to Burundi, you know, we want clarification on a few things, you know. So what did he tell you exactly that he was going to do? Please repeat that. He told me he was going to meet the leaders. Did he tell you the names of those leaders? Yeah, I know one of them. One of them is called Brigadier General Jeva. There was another one from who was in the Congo, but he said he was going to meet them and help them because they were facing some issues. How about Burundi leadership? Did he tell you the leaders he wanted to meet? No, he never told me about the Burundian leaders he wanted to meet, but he told me he would meet some leaders because he's the one who informed me about his trip. And that was the starting point. And Your Excellency, you know, news, when there's thunder, the news of that thunder is told by the one who was not stricken. So I had to investigate personally to know this individual. In a nutshell, he was going to Burundi to meet the leadership of his armed group. Was that the first time he was going to Burundi? Did he tell you? Did you ever talk about that? He once told me a long time ago, before the 90s, maybe in the 70s, we were talking about schools and stuff like that. But it was the first time he was going, and that's why he was asking me, as a person, as an acquaintance, asking me if I could come with him on that trip. But I don't know if he had been there before. I'm not sure. Let's ask one final question from the court. Rusesabagina will have time, or the prosecution, to ask you questions. Apart from talking with Rusesabagina on the plane, that plane that brought him to Kigali, and you asked him to lie down. Did you sedate him in any way? Sedating him? Yes, that's the question. Any tablets you gave him, any drink that caused him to go to sleep? Well, ask him personally. We both went to sleep. We shared whatever we took. We were served by the same air hostess, and we went to bed. And I didn't have any personal drinks that I brought on board. They served the drinks, and we drank, and we went to sleep. I didn't give him anything. Okay, does anybody else want to ask this informant and any questions? Rusesabagina and your defense or the prosecution, do you want to ask him any question? I see Rusesabagina in his defense talking, consulting. Anything? No. The prosecution, anything you want to ask the informant? If you want the court to ask the questions for you, we can do that. Thank you, Your Honor, honorable judges. The prosecution had asked for this informant to explain a few things to the court and also be asked and answer a few questions. The prosecution is satisfied. Thank you. Well, last question. Mr. Constantine, what motives did you have to seek justice for those people? Why did you want to do everything you could to bring Rusesabagina to justice? That determination was rooted in my activities, in my status as a person of God. If you're going to heaven and once you find out that somebody is involved in killings, you're not going to keep quiet. He told me, I don't care people died. That's not a problem. I'm just disappointed that Sankara has publicly acknowledged the killing. From that very minute, I said, this is horrible. I met a horrible person like this. So that determination is rooted in the Word of God. I knew then that I could not associate myself with people who commit acts like that. You know, I've also mentioned those images of the victims, people crying, orphans. The Bible tells us not to kill, not to shed blood. In the Genesis, it says the tears of your relative is crying out for revenge. And I could also say, well, it's the Holy Spirit that pushed me. I kept praying. I was fasting. And I was praying to God, please make a miracle for those orphans and widows to get justice. So only God helped me. Those are the things that motivated me. Weren't you motivated or pushed by Mike or that Michelle, Your Excellency? People can do things. Many of people can do things. But please look at this way. I'm a bishop. I know no karate. I'm not a soldier. I can't fire a shotgun. I had two things. Well, there was two things. I could die and I could get out of it safe. But I was determined, like I told you. If you know what's good and you don't do it, then that's a sin. That Mike, Michelle, never did anything to push me. I'm the one who came up with the idea and shared it with Michelle. I'm not scared. Whatever happens, I did what I had to do at the right time. Thank you very much.
Uretse Rusesabagina,
is there any, apart from Rusesabagina, is there any member of the FLN that you had conversation with or contact? Apart from Rusesabagina, I repeat, somebody in his in these groups, FLN and so on, that you spoke to? Well, there are some he showed me. One day, he showed me some of them, but I wasn't in contact with them. There are things that that I may say when you wish to give me more, you wish me to give more testimony, I will cite names. No, the question was, did you meet any of the FLN MLCD that you spoke to? Yes, there are some that I spoke to. Thank you very much. The court, thank you. As you say, today was just general information about his coming. The rest, when we come to the actual trial and we need you, we shall call you. So we thank you for this information. Thank you very much. You may take your place. Don't go away, because there is something that you need to sign afterwards. Please don't leave. You may just take your seat. So, prosecution, you wanted to discuss the issue of RUSESABAGINA's coming to Rwanda, but we've only got 10 minutes or so. So please be brief if you have anything to say. Thank you, Mr. President. After the informant has spoken, we had said that we shall, after the information, we shall continue to discuss the issue of kidnapping and use of force. We had already said that there was no force used, and now we have heard how RUSESABAGINA came from Dubai to Kigali, and I think you have all seen that there was no force used, no coercion. The informant has explained exactly as we had exposed to the court. And but Mr. President, there is something that we want to add about the use of force, where we've already said there was no force used, and the bishop has just said there was no coercion for him to leave, but he was tricked. It is a fact. Bishop Constantine Nimungiri, he has already told us that he tricked us. The aircraft personnel knew we were going to Kigali. I knew we were going to Kigali, except RUSESABAGINA, who thought he was going to Burundi. So therefore, he was not kidnapped or abducted. The second, no law was broken. Even the way RUSESABAGINA and his lawyer had said, whatever they said, they didn't bring up any law that was broken. They just say he came here illegally, and we were expecting them to bring any law that was breached, but there was nothing like that forthcoming. So, but also, Mr. Sabagina was not the first who came to his country where he was being prosecuted or investigated. This is not the first time there has been cases like that, but we can say that he was probably hoodwinked, but no, not coerced. The European Court of Human Rights has also ruled on a matter related to such a case. This is the case of Watestoke versus Germany. And we could have gone into this case and shown how it relates to Rusesabagina's case, but we don't have time. Briefly, we can say that the connection or the resemblances or commonalities between the two cases are as follows. This is a German citizen who was imprisoned due to income tax embezzlement. He was in a provisional detention, but he did not follow. He infringed his detention. He fled from Germany to Switzerland and again to France. And one of the other co-accused or co-suspects worked with the court, cooperated with the court, and said he could find him, help them find him and bring him back to Germany, to justice in Germany. Well, this is a long story, but the co-accused told him that there were people who wanted to do business with him, and then he took him to a meeting in Luxembourg with those people who wanted to go into business with them. And when they met, well, I won't be long because we don't have time. In any case, it's already in the system, and the court case is also available, has been made available. But anyway, in short, this man, Walter Stacke, was brought back to Germany because his co-accused told him that there were business people who wanted to meet them, and then they took an aircraft going to Luxembourg, so-called, but he didn't. It went going to Germany instead. So Walter Stocke was rearrested, tried, and condemned to 6 months prison. And the courts, when he finished the process, because he appealed, and then he also accused his colleague Costa, the one who tricked him into coming to Germany, where he lost. He even, sued the pilots. He also lost. Then, after all the whole process, then he went to the European Commission on Human Rights, saying that he shouldn't have been tried because he had been kidnapped, or at least he was apprehended illegally. And we found that the facts are similar to those of those that we are discussing in the case of Rusesabagina, how he came to Dubai and brought to Rwanda. So therefore, what the court has, how the court has ruled is proper, because there are precedents, and these precedents are similar cases. The European Court of Human Rights, when then ruled, well, Stocke explained how he was apprehended, and he said it was against Article 5, paragraph 1C of the Human Rights Convention. And although we're not going to read Article 5, This is the same as what appears in Article 9 of ICCPR, which is what RUSESABAGINA, in his argument, has based himself on. The European Court of Human Rights explained how this court, or rather how the way RUSESABAGINA was apprehended was not different from the case of this German man, and therefore no human rights were infringed. He appealed, but the appeal also concluded that, or ruled that no law was broken, and that instead they separated two issues. This man, the German, flew from France to Germany, and the way he was arrested and imprisoned and then tried. The court, the European Court of Human Rights, explained that there was no law that was broken, neither in France nor anywhere. We shall read these paragraphs.
Neither the facts found by the Commission nor the circumstances of the case as a whole established that the cooperation that there had unquestionably been between the German prosecuting authorities and Mr. Costa had extended to unlawful activities abroad, such as returning the applicant against his will from France to the Federal Republic of Germany.
So therefore it's clear that nothing in the process broke any law. Whether the whole case as it happened, or the cooperation between the French, or rather between the German authorities and Costa, the one who engineered the whole exercise, that no law was broken. So Walter Stocke came from France to Germany, and no law was broken. By the way, Mr. President, we cited Porcel, the one who said that you may have been arrested badly, but tried properly, and therefore it's okay. If a person was brought to justice, you having been tricked into doing it of his free will, there is no law that was broken.
Both the plane, entre parenthèses Stocké, or both Eunice Yinindikes yari yavuze mu gitabo cye, of his own free will and not under duress, he comes voluntarily to a jurisdiction where the arrest can be executed. In that view, there is nothing wrong with this technique as long as that person arrives voluntarily in the jurisdiction where the arrest is effected. Mr. President,
So, Mr. President, we conclude in saying that, as we showed the court earlier, there was no kidnapping, there was no abduction. He himself has said that nobody used force, nobody coerced him. We also have shown that there was such a case, a similar case, similar to that of RUSESABAGINA, as we have just mentioned. And we might add that the European Court of Human Rights, this is a supranational jurisdiction that deals with human rights. This court decided after all the internal legal process in Germany had already been exhausted. And even in France, he had already sued the police, or rather the pilots of the aircraft that brought him. He lost. The court said that there was no problem, and that no human rights were violated, and that in fact the decision or the ruling is very clear and explains that very clearly, that it shows therefore that Mr. Rusesabagina was not brought illegally, and therefore there is no reason for him to claim that. Thank you. Thank you. Mr. President, this is very easy. My part is easy. They were asking for the my client to be released, and he said he had been kidnapped, and that even when he was detained in Rwanda, there was no the legal process was irregular. And he also said that Article 29 and 31 were not respected. But we shall not insist on this anymore. We have already presented a written statement about that, and a written objection, which is in the system. There was already an international warrant, arrest warrant, since 2018. Mr. Sabagina knew of it because it was given in Belgium and Interpol as well. And the witness, or rather the informant, also mentioned it because he had already told the informant that because of that international warrant, arrest warrant, he cannot travel to Africa or to Europe. So when he arrived in Rwanda on 28th August, he has no complaint from that point. The only problem he had was on 28th August 2020, where the prosecution asked for his requested for his imprisonment. At that time, he had already been appraised of the indictment and its content, and in fact, he was given opportunity to discuss it. And then on 11th of September 2020, there was a process, or a court case, where he was asking to be released. And there was even a decision on 17th September 2020, a decision to detain him provisionally. Later, they were asked for the period to be prolonged, and it was done on the 13th of October. But the decision, the ruling was taken a bit later. Of course, there was an appeal process, but the appeal court maintained the previous decision. So, Mr. President, in all these cases, there was never any mention of the law having been broken as regards his provisional imprisonment. Another thing we can say, the the Penal Code provides that provisional imprisonment is in order in his case. The reasons were given and the justifications were also given. Further, I think they have tried to twist the meaning of the articles of the law. For example, when they say that Article 29 to 31 of the Penal Code or the penal the criminal proceedings, what they say is wrong. There is no obligation for the prosecution to first write to the accused and before they bring him to court, because he's already been arrested and tried, and you cannot write. You do not need to write a convocation. And as to the main levée, the annulment of his imprisonment, they brought this issue back in their introduction, saying that his rights were breached, basic human rights, because he was not allowed to choose his own lawyer. Actually, this issue was not really discussed. They didn't say at what stage he lost his rights to have his own recruited lawyer. What instance deprived him of his right? He didn't say that. But what I can say, this issue of defense rights was brought up, I think, in the paper that they called Information. And then again, on the 5th of February, we explained this matter and gave all the details of what happened when he was arrested, up to the point that he is now in this court. At all stages, his human rights were respected. The only thing that he was not allowed, or was those things that he asked that were contrary to law. But all that was legal and he requested was granted him. So kidnapping, main levée, and all these issues that they keep raising, we had already concluded on this. We had already shown that the main levée, his request to be released, and then because he was kidnapped, these things are not connected. There is also something that he said usually you don't find in the arguments. He said he is in Rwanda illegally. On our side, as a prosecution, we should want to reassure him that he is here legally. And we'll come back to this when we will come to the subsequent trials. He was wanted by the authorities in Rwanda. He was brought here to appear or to answer legally. So this is a conclusion. Therefore, the objection about the release, the objection that they presented asking for release is does not stand, has no standing, because it depended on his claiming having been having been kidnapped. He hasn't been kidnapped. Second, there are processes regarding temporary or provisional release, because there are conditions that were not respected. There have been infringements on his side, and therefore that request cannot be granted. So therefore, the objections that were presented are unfounded. Thank you very much, Mr. RUSESABAGINA. Mr. Rudachemwa, you have anything to add that to what has been explained by the prosecution? Especially the matter regarding kidnapping and so on. He did not say anything about. You didn't seem to have insisted on the other point. You have the floor. Thank you, Mr. President, honorable judges, the session has been long, and I think I want to be brief, and I just want to respond to some of the points regarding kidnapping. I think they said here, I noted here, he said kidnapping cannot occur if physical force was not used or coercion. And also what they called country B will have to be involved. But in the case it wasn't. And there has to be an infringement of the sovereignty of one country by the security forces of another. Where these definitions are no standard definitions, you know, they are personal definitions. Well, there's some precedent that was cited and the doctrine that was cited. But I think there can be coercion that is moral. And there was no answer about that. Therefore, RUSESABAGINA his case is very interesting indeed, because the prosecution has admitted themselves that if you trick somebody, you cannot say that he was kidnapped, but you tricked him, so it's a kidnap. It's an abduction. Yes, sir. They say there was no kidnapping. They they tricked him. That's what they said. Okay, so thank you, Mr. President. What we wanted to say was that when the process, the due process was not followed, then there is vice. It's vitiated. For example, there has to be an official document by a judge for a person to be brought to justice. If there is no such document, any other ways, whether violent or not, are illegal. A person was brought, was hoodwinked into going where he hadn't planned to go. So we should like to know, Mr. President, among all the things that has been said over the last 5 years, the way RUSESABAGINA arrived in this country, was there a document signed by a judge ordering him to be extradited? If we don't answer that question, then we just go on saying that there wasn't use of force, and go on and on and on and on. Because if you can't give that argument, he will have to be released. And also, let us, all the things that came afterwards should be ruse policière or police tricks. They call it ruse policière. That is a trick by the police to get a person to go where they want him without force. Yes, I know, but there should have been a document. Whether it's the police or anybody, a trick is always a trick. So it is no. So is it the issue, sir? Is it accepted or not? Can you trick? Can the police or the security forces trick somebody into getting arrested? Yes, I know. I don't disapprove. I don't disagree with rules, but there has to be a document. Yeah, that is contradictory. You can't. You either use rules or you write papers. It cannot be both. You understand? It's either one or the other. So they didn't. The court. What is before the court is if police tricked someone into surrendering themselves, or rather coming to Rwanda, for example, in this case, is it kidnapping or is it not? Just answer that. Yes, of course. You know, I hope you can hear me.
bukoreshwa kugira ngo bwaba igitugu bwaba gushuka umuntu.
So if a person is tricked from one country to another, I think it's against the law. Take him to another country without their realizing. Can I continue? Because I think my lawyer has concluded. Mr. President, prosecution said that RUSESABAGINA was not abducted because there was no use of force. A question. If somebody kills somebody with a weapon, and it's obvious, everybody says he's a killer. What about somebody who poisoned somebody and he dies, isn't he also a killer? Yeah, let's your lawyer help you. What is the name of that? No, let him take note, he will answer. Continue. Both of them are homicides. So, if you trick somebody and you throw them in the water, but or they fall into a pit and they die, it's the same. Although you didn't cut their throats. Therefore, if somebody was tricked into something bad for him, it's not necessary for that to have been force. The evil outcome is still evil. And they say there were no Rwandan officers in the US, Belgium, Dubai, none was found there. But Constantino Mungere has a Rwandan passport. He works here. He works with RIB. How do we know he's not a RIB officer? And they say that my imprisonment was legal. Well, what do you mean? Somebody has been kidnapped. You take him to a place he doesn't know. And on 28th August, and then you... it's only after 4 days that you produce him. This is what happened. He's in a place he doesn't even know where he was. He was tight, and his face was his eyes were tight. He couldn't see. Why didn't they take me to prison? I said, this is a prisoner. We shall produce him tomorrow. They say he had no problem with lawyers. So on 31st August, RIB interrogated me. There was no lawyer. On it's only on the 1st that the lawyers came. I understand there is 110 advocates or lawyer. They brought 3 that I didn't know, and because I insisted. So they said I should choose 3 people to choose from. So they say, I bring 3 and say, choose 3 lawyers. What choice is that? Then my family chose a lawyer. I only saw him 1 month later because he was prevented from seeing me. My normal lawyer in Belgium, Vincent, so that the registrar can register the name. He's my lawyer, it's always been. He came here wanting to meet me. Not even 1 second. Doesn't even know how I look as a prisoner. So I look for international lawyers. I'm still asking for international lawyers. I wrote a letter on 29th. I wanted an American an Australian, and a Canadian. Now, this is, you're now going into another issue. So don't go into that, because you've already made your point. Okay, complete your sentence, your argument. Go on. So I wasn't detained legally or lawfully. No, I said complete. Finish. I said finish. It's not the point here, but please go on. Say what you want to say. Okay, thank you. So I want international lawyers and I don't have them. Who refuse? Who refuse? I don't know. I don't know. I just know they didn't come. I don't know who refused. And I'm the only one. The only accused who do not have their own choice of lawyers. I want international lawyers. Oh, I think I have finished, Mr. Chairman, Mr. President. So, do you have anything to say? You objection, Mr. President. Please, the court should help us come back to in line. RUSESABAGINA said he didn't have lawyers. But lawyers, he didn't say that in his written submission. No, but that's your problem. He brought it up, you replied. You should never have replied because it wasn't in line. They did not have it in their write-up. They didn't even explain fully what he just said. He said 3 lawyers we could have explained. There are explanations. Okay, he got it. In fact, he knows. He knows that this is not a point today. And even what I'm saying is that you yourself should never have answered, because this is not the point of this this hearing. What we wish is that these things that are not connected with today's issues, they should be removed. Okay, I think the court has just explained. We will not remove them from the summary, but in any case, it's your fault. You should never have got into it because it wasn't the issue. And RUSESABAGINA has also agreed that this is not the issue for today. So, Mr. Rudakemwa, no. Lawyers, no. Lawyers, you did not bring this issue in your write-up. No, says the lawyer, we were just responding to what the prosecution had just said. They said that a choice of lawyers has been respected, but my client just explained that he didn't have a choice. He wanted international lawyers. No, don't go into that, says the president. Just conclude. No, conclude. Because is this now a new objection? Are you adding to your objections? You mentioned this, and then the prosecution also went into that. You should not bring this up because it's not in your objection. No, it is not in your objection. Later on, if you want another objection, you can write it, but we cannot go all over the place. If he has something to say, let him also bring the issue up, but properly. Okay, so please, we're not going to go, is it a different issue? Oh, it's because the prosecution mentioned it. Okay, you can have now a rejoinder briefly. Please, even in the prison, when we went to the prison, this issue was brought up. But if we told him that since you have lawyers, you know what to do, when you have an objection, you present it. Today, the issue was his imprisonment and so on. Okay, I have your objection here. Except, by the way, the last page is repeated twice, so be careful. No, we raised it because the prosecution raised it and said we had not. No, it's not. This is not its place. No, yeah, but this is not part of your objections, says the president. It doesn't come into this because you presented your objections. We are examining them. Don't add anything else in the process. I mean, you are a lawyer. Surely you know the law. Today we have an item. You cannot be adding on. If you have other issues, you will bring them up, but you know the process. You can't just drop them like that in the discussion. Okay. All right. So I think now time we have run out of time, and I think I should ask my colleague to conclude. I think you had concluded. So if everybody has said what they want to say, that's fine. Yes, sir, Mr. President. I think the prosecution has expressed its views fully. The objection that was presented has no standing because Mr. RUSESABAGINA, even up to this moment, has been brought legally, the prosecution says, but we insist that it was illegal. He was kidnapped and should therefore be released, so that also the process, the whole legal process that took place afterwards be annulled, be declared null and void. By the way, a question: I wanted to ask this question, but I think this is the time. What are the legal consequences of main levée? You mean annul the process or annul the decision so that he can be tried out of prison? No. Answer that, please. Do you want him to be released and then come to court from wherever he will be, or what? No, Mr. President. If he had been kidnapped, he will be released, and then the decision of provision or imprisonment will be annulled, and he will go back to his initial state status before his kidnapping, so that all the rest of the process that took place afterwards will be null and void because it was illegal. So this is the foundation. If the foundation is shaky, then the house will not stand. Thank you.
Thank you.
Okay, urukiko
Now the court has finished the pleadings on this objection. The ruling will be read on 10th March.
mwana turi kuvugana ku isi
We're consulting on the time. We need to consult as a team.
okay twumvikanye ko tuzasoma saa
The ruling will be 10th March. It will be Wednesday, 2 p.m. You see, you've dealt with many issues. We will take time to write out the decision. Now, the registrar will print out the report, then the parties will sign, and that's the end. Thank you.
Nyamwongere Constantin.
Nyamwongere Constantin, please come forward. Samana Karist and his defense lawyer. Timon Herman and lawyer, Better Ruggiero.
Rusesabagina Paul n'umwunganizi we Maître Rudakemwa Jean-Philippe. Mukandutiye Angeline Mutakamba Jean Berkimas n'umwunganizi wabo Maître Mukaruza Yiriza Chantal. Shabani Emmanuel Nsabimana Jean Damascene alias Motar n'umwunganizi wabo Maître Uwimana Shani. Shabani. Shimimana Emmanuel, Nirora Marcel, Yamuremye Emmanuel n'umwunganizi wabo Maître Uramije James. Bizimana Cassien, Nizeyimana Marc, bunganiwe na Maître Murekatete Henriette. Nsanzubukire Felicien Munyaneza Anastase n'umwunganizi wabo Maître Twajamahoro Herman. Félicien. Kwitonda André, Hakizimana Théogène, Ndagijimana Jean Chrétien n'umwunganizi wabo Maître Mugabo Sharif Yusuf. Ganinde. Byukusenge Jean-Claude, Nikuzwe Simeon, Habanganyimana Joseph, Biramira Innocent n'umwunganizi wabo Maître Ngamije Kirabo Guido. Ganinde. Joseph. Abaregera indishyi hari Maître Ndutiye Yusuf, Nsengiyumva Vincent, gauche, Maître Bagabo Jean d'Amour, kampani ya RFA ihagarariwe na Nkutizera Bertin na Omega ihagarariwe na Hakizimana Tatien.
These are those suing for compensation.
Rwegesa Phineas, Rudahunga Ladislas, Rudahunga. Nyirayumve Eliane hagarariwe n'abavoka Maître Mugabo Fidèle, Mukashema Marie Louise, Maître Mulisa. Aba bavoka uko ari batatu nanone bakaba bahagarariye abaregera indishyi bagera kuri 84.
So these three lawyers represent over 80 persons suing for compensation.
Marie Louise. Mugabo Fidèle. Alice yagiye. Bosnia kawe umudamu we. Arahari. Alice. Okay, mwakoze cyane.
Thank you very much all. I think it's been a long day, but we have now concluded today's trial.